grant 2 weeks to comply the order, my lord.
No, we will not grant.
Yes, my lord. Kindly see the order last.
Yes, order has not been complied with.
It's the central government, I think, so we are not the parties to.
All right.
It will also see. It's not so. Ministry of Defense South Block Museum. I think somebody there in the screen or some officer is there.
Present, sir.
Yes, have you complied with the order?
Sir, the order has been passed for the compliance, your lordship. But there's a Ministry of Defense letter, sir, which has been directed that a legal view internally should be taken from the ASG with respect to the review petition for the condonation of delay. And the opinion has already been sought from the ASG, sir. And but they have already forwarded the file to Ministry of Defense, Department of Ex-Servicemen Welfare, sir. And but the file hasn't reached with the Joint Secretary ESM. So, sir, once it will reach, so the sir, the compliance.
When was the order passed?
Sir, it was passed on
4/3/2022. 4 March 2022.
Yes, sir. Yes, sir.
And it has taken 2 years. When did you file your review application?
Sir, the review petition has not been filed, sir. We have sought an opinion from the ASG with
Very
respect
difficult.
to.
Then you may file your review application after the contempt petition is disposed of.
Right, sir. Right, sir.
We are proceeding against you.
Sir.
Who had to comply with the order? Jagdish Chandra Mohanty?
No, your lordships. It's Joint Secretary,
Girdhar.
ex-servicemen association, your lordships.
Let us see.
Sir. Your lordships, if some additional time may please be granted, your lordships.
Sorry, madam.
Your lordships, 1 week would be the last.
Let us see the tenor of the direction.
Yes, your lordship.
No, you have already committed contempt.
Yes, your lordship, the file is going up in chain, your lordship.
We are not concerned with that.
Yes, your lordships. Your lordships, it's already in the process of complying. It just the file has to reach.
We don't think.
Secretary.
We don't think so.
Your lordships.
Any interest in complying with the order?
Your lordships, just last 1 week's time, if may please be granted, your lordships.
What
for? We should adjourn it.
Sir, your lordships, the contemners are not concerned with the compliance, your lordships. It's the Joint Secretary, ex-serviceman, who will be finaling doing the compliance, your lordships.
So he should be included as party. What is his name?
Your lordships, we have not filed any case for Ms. Joinder, your lordships, but since it comes under
according to madam, according to you, the name whose name is there as contemptor in the contempt application is not the person who was required to pass an order.
Yes, your lordship. The file has to process to the contemners, and it has already been processed. Now it is Joint Secretary, ex-serviceman, who has to finally comply.
So let him be punished first, madam. Let him be punished first, and thereafter he may comply with, he may not comply with. We will see.
Your lordship's requesting if some 2 to 3 days, if may please be granted, your lordships, for the last time, your lordships, please.
MS, what is your name?
Sir, your lordships, my name is Captain Akanksha Singhal. Your lordships, I'm OIC
Captain
legal.
Akanksha Singhal.
Yes, sir. Yes, your lordships.
OIC legal.
OIC legal. Yes, sir. Yes.
Who has joined the court proceedings online, has sought by way of last indulgence 1 week's time to comply with this court's order dated 4/3/2022. Stop. After having perused the said order dated 4/3/2022, we are and the materials on record, we are satisfied that the this court's order has been violated without any valid explanation. Stop. List this matter on 1 week. Stop. On the next date, the contenders shall be under obligation to inform this court that the court's order has been implemented fully. Stop. It is further observed that in case the said order of this court is not complied with, the MS Akanksha Singhal
Yes, your
shall be
lordship, my name is, yes, sir.
shall be required to furnish names of all the officials who were required to carry out this court's order, required to carry out this court's order from the date when the order was passed on 14/4/2022 till date, so that the court may proceed against them for contempt of court. Yes.
Much obliged, your lordships.
Item number 3.
My lord, the appellant wants to withdraw with liberty to approach the appropriate forum.
Appropriate forum.
Execution order of the civil court. Execution proceeding is already over. He's suppressing that.
So why should we give you this liberty?
My lord, inadvertently I filed after verify. I think this is it should not be filed, so I want to withdraw and approve
liberty.
forum.
No liberty.
There you suppressed the material fact.
And counsel
The
appearing on
execution
behalf.
proceeding was completed.
Now the appellant seeks permission to withdraw this writ appeal. This appeal is accordingly dismissed as withdrawn.
Item number 4.
Formal Simon.
Pursuant to lordship direction, Lords, the Tahsildar is present in court today. Lordship had directed the Tahsildar to dispose of the lease case, Lords. If you also look at page 10 of the brief, Lords, there is a direction to the Tahsildar to dispose of the lease case. The Lords order is as follows, Lords. Paragraph 3, OP number 2, that is the Tahsildar is expected to deal with the case by 31st of January 23. It goes without saying that petitioner expects the requested disposal. Now, Lords, has already sent the records to the sub-collector for settlement of the, because he cannot, it's a de-reservation, it is to be.
So who is for the petitioner?
Manoj, I'm for the petitioner.
Yeah, what is the order which is to be complied with?
Your lordships, this is the order. What had happened, my lords, lands had been allotted to us.
No, we are not required to go into the facts. We are required to see the order.
I'm just explaining the background of the case. Lands had been allotted to us, my lords. And thereafter, my lords, the lands were taken over by this honorable court for building the judicial academy, my lords. Thereafter, there were your lordships directed that this should be an exchange of land should be done, and we should be given the land in lieu of the land.
Mister, what is the direction issued by this court?
This is the direction, my lords, that by
What?
January 2023, your lordships have held that he should complete the lease proceedings. My lords, they are not allotting lands to us.
January?
My lords,
When is that order?
1/12/22 in WPC 25496 of
There is absolutely nothing in the order. The
No.
opposite party number 2 expected to deal with the case by 31st January.
yes,
It
my
goes without saying that petitioner expects to be heard. There is nothing.
lords, The thing is, my lords, they should have completed the lease case, and your lordships have already
No,
come to a finding that there is contempt of court, my lord.
No positive direction.
Your lordships will see order dated 24/4/24.
We have seen.
Yes, my lords.
That is an incorrect order. We must have noticed, we must not have noticed this, the tenor of the order. There is absolutely nothing.
My lords, can they keep us waiting indefinitely?
Yes, they can, because this was the order which you received, which you
No.
accepted.
This is the order which says
Order, there is no direction.
My lords, by 31st January 2023, they should complete the proceedings. my
No,
lords.
no, it is expected.
It is expected.
Deal with the case.
Yes, my lords.
They are dealing with the case.
Can it go on
If
for?
there is no direction that they should complete. And we shall go by the words of the order which has been passed.
Your lordships may issue a direction to at least.
We cannot issue direction in contempt proceedings.
So with all humility, he has
Pursuant
submitted the
to-
records to the, he has done his part, my lords. He has submitted the
pursuant
records to
to-
the higher authority.
Pursuant to this court's order dated 24/4/2024. Mr. Manas Ranjan Bhoi, Tahsildar Cuttack is present in court. So he has submitted that to the extent he was required to deal with the lease case,
Yes, ma'am.
he has completed his part and has sent the records to
Sub-collector Cuttack, my lords,
sub-collector.
on 23rd of April.
Cuttack. Stop. Next, it is noted that the petitioner has alleged disobedience of this court's order dated 1/12/2022, paragraphs 3 and 4, 2 and 3 read thus. Stop. Next, in view of the submission which has been advanced on behalf of, in view of the submission made by the contender, so and so boy, in our opinion, no case of deliberate disobedience of this court's order is made out. The present contempt proceeding stands dropped. Yes.
Obliged.
Vijay Kumar Patni. Personal appearance stands dispensed with. Personal appearance of so and so stands dispensed with.
Item number 5.
My lord, let it come after 2 weeks.
Why, sir?
I was sick, I have not prepared.
All right. When do you want?
My lord,
When do you want? Cup,
after 2 weeks, let it come.
as requested on behalf of the applicant, list this matter on 2 weeks.
Item number 6.
Item number 6. May it please your lordship.
Yes.
My lords, I am challenging the order of dismissal by the learned single judge, by which my writ of, I had filed a writ application praying for refund of money towards an excess area for which I have paid in an e-auction. May I please the facts, my lords? My lords, one e-auction notice was noted by the respondent bank, which your lordship will find in the writ application, my lords. Which your lordship will find in the writ application, page 10, my lords. Page 10 of the writ application. My lords, as per the e-auction notice, one thing was very clear, it is on an as is, where is basis.
Yes.
My lords, I am the successful bidder in the e-auction. I, along with the appellant number 2, I purchased the property. My lords, at page 10, your lordship will find the area of the land is acre 25 decimals. The ROR also states 25 decimals. My lords?
25 decimal.
Yes, my lords. And the ROR also reflects it is 25 decimals. Thereafter, my lords, after the sale certificate was issued in my favor, I conduct a demarcation of the property through a private Amin. Your lordship will see the report of the Amin at page 19 of the writ application. Page 19. My lords, the Amin report clearly states that the area is a total of 18 decimals. So there is a shortage of 7 decimals. I make representations to the bank to refund that excess amount which they have taken towards the 7 decimals, which amounts to an odd amount of rupees 9 lakh something. They do not take any action. I file this writ application. Your lordship may see the impugned order, which is at page 14 of the appeal.
Yes.
The relevant portion is para 5, page 15. May I please it, my lords? Learned counsel for the opposite party's bank submits that the petitioners were aware of the size of the land at the time of transfer of the said property to their name, and they purchased with sufficient awareness. The principle of caveat emptor should have followed by the auction purchaser at the time of purchase. Considering these facts and circumstances, this court is not inclined to consider the prayer, and on this ground, the writ application has been dismissed. My lords, my first ground in this writ appeal is that even though the sale notice, the e-auction notice says that it is the auction will be on the what is basis. My lords, the principle of as is what is basis or even caveat emptor cannot be extended to a point where the bank is selling me a certain amount of land, and they are saying that I already know that I am purchasing a property which is short of the amount of land which is stated in their own auction notice. So that is my first humble submission. Second, my lords, even if as per the principle of caveat emptor, the duty is on the purchaser to verify, to find out what are the encumbrances, liabilities, etc. There is an equal duty on the seller, which is the principle of caveat venditor. And as per that principle, my lords, the bank should not have concealed any material fact which could prejudice my choice of purchasing the land in any manner.
No, you had seen the land.
My lords, I had seen the land. Definitely, my lords, I bow down. I had seen the land. And as per the ROR, in fact, your lordship will see the area is 25 decimals. And I requested them multiple times that I want to make demarcation of the land, but in a hurry, it was sold off. I thereafter inquired and made a demarcation of the land
No,
for a
but you
private.
were not stopped from measuring the land.
My lords, I agree. But my lords, in the writ application, when the bank appeared, they are specifically, your lordship will see the order. The honorable single judge had directed them to file an affidavit.
There may be a situation where some of the bidders might not have participated because they might have found that in fact
My lords,
so why should they go for 25 decimals?
My lords, in reply to that question, my lords, even if the area, assuming also the area was 18, the principle of caveat venditor, the bank should have informed me that even though the ROR area says 25 decimals, this is an area of only 18 decimals. On one hand, they do not exercise the duty of caveat venditor, and they ask me to buy the entire land. I pay 33 lakhs. 9 lakhs in excess of the land which I have already paid, for which the possession has never been given to me. My lords, in this regard, may I just place one judgment just to show my lordships the interplay between as is what is and caveat venditor. This is a judgment of the Honorable Delhi High Court. Because I'm showing this judgment because multiple judgments of different high courts and also multiple judgments of the Honorable Supreme Court have been followed. My lords, to be fair, my lords, this matter that I'm placing, this particular judgment, this relates to a case where the bank suppressed an encumbrance on the property. And in spite of that suppression, the land was purchased. My lords, in this
difference between that and
my lords, what I'm trying to submit is that if in a case of encumbrance, a particular encumbrance or a mortgage which was suppressed by a particular bank, this the Honorable Delhi High Court and other multiple high courts across the country, as well as the Honorable Apex Court, have held that the buyer is entitled to refund of its money.
No, somebody, I think for bank, somebody is appearing.
Someone is appearing for the bank.
My lords, in the writ, Mr. Tunna Sahu was appearing for it's UCO Bank, so he regularly appears.
Here notice has not been.
No, this is a fresh matter, my lords. Fresh matter.
So notice. 1 week.
Item number 7.
Grateful.
On behalf of Dr. Vinod Kumar Mishra, it has passed over.
As requested on behalf of the appellant, is this matter on 1 week.
Passed.
Sorry.
Item number 8.
My lord, may it please your lordships. This is that junior teacher matter, my lord. And if my lords are graciously pleased to take writ appeal number 712.
Sure. 712, which page?
If my lords are kindly pleased, my lords, to take writ appeal 712.
Yes.
And your lordships kindly turn to my lords, page 72.
Which annexure?
My lord, annexure 2, page 72.
Yes.
That is the resolution of 22nd of August 2023, my lord.
Yes.
Your lordship may see the very first line, subject guideline for engagement of junior teacher schematic. My lords have it. My lords. And then the right of children to free and compulsory education act 2009 came into force with so and so. In accordance with the provisions of section 38. No, that's, I leave it at that. My lords may kindly turn to 78, page 78.
Yes.
This is the selection process. My lord sees, my lords, 8.1 talks about a master list, and 8.2 is very important from my perspective. My lords have 8.2. An online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement, to be published before the recruitment. So there will be, my lords, a test for determining the merit of the applicants who apply for the said post. That's the submission. Your lordship now sees 8.3. 8.2 therefore contemplates how the examination will be made. And 8.3 says, in my humble submission, once you have the merit list, how will you distribute it within the districts? Now, if I read it slowly, district-wise and category-wise, draft merit list will be prepared by OSEPA. Draft merit list will be prepared taking into consideration all district preferences submitted by an individual candidate in order of preference followed by merit rank. So therefore, merit is also one of the components to be considered even under 8.3. That is, for a particular district, after exhausting all candidates having first preference, subsequent preference will be considered. In case of time, we are not on time. Now, kindly see, minutes, one more page, and that your lordships will get at page 85.
There is only one thing which is lacking in this.
I'm grateful.
That the merit list shall be prepared on the basis of test held under 8.2.
My lord, 8.3 does not say that, but 8.2 says that.
8 point says that there shall be a test.
I'm grateful.
But what should be the criteria
Yes.
for preparation of merit list?
Correct.
That is not there.
I bow down, my lords. But 8.3 also refers to a merit list. May I read it again, my lords? May I read it again?
Mhm.
District-wise, category-wise, draft merit list will be published. So there is, a merit is there. Even over the page, my lord, merit is there. Now let us see, my lords, one more important page. Your lordship may kindly turn to page 85. What happens after this is issued? My lordship, have it, my lords.
Yes.
This is 10th of September 2023. It is for information of all concerned that in pursuance of School and Mass Education Department, Odisha resolution dated so-and-so, letter dated so-and-so, 20,000 junior teacher schematic posts will be filled up in the primary and upper primary school under different revenue districts of Odisha. The information of district-wise, category-wise post will be available in OSEPA website. So-and-so. Applications are invited from intending candidates to apply for the post of junior teacher schematic through online mode only from 13th of September 2023. The last date of submission of online application form is 10/10/2023. No other mode of application will be accepted. There will be no examination fees. Number one, next line is very important. The candidates will be selected on the basis of marks secured on computer-based test, CBT computer-based test examination. The syllabus of the CBDT is available in the OSEPA website, the date and time, etc. I am relying heavily on this line. The candidates will be selected on the basis of marks secured in the CBT. My lord, none of the petitioners who are before your lordships challenged this, participated in the examination, and in my humble submission, my lords, they are now stopped from saying that the marks of the CBT have no relevance with their selection. Now your lordship may kindly see, my lord, I will not take much time. Your lordship may kindly come to page 106.
Yes.
Kindly turn to, my lord, page 106, which is annexure 6.
Yes.
My lords have it, my lords. My lord, this is an affidavit which I had filed before the learned single judge, my lord. And if my lords are kindly pleased to turn to 110. My lord, the writ petition had 4 petitioners. Had 4 petitioners. And kindly see, my lord, what was the position taken by us? My lords have it, my lord. May I read now? Paragraph 7. Kindly see, Chintamani Bhuiya was the petitioner number 1. And Chintamani Bhuiya had applied for category 1 science and category 2 science. Just as an illustration to show your lordship. So this was petition number 1. He is a person from Cuttack. He had applied category 1 science and category 2 science. Now, my lord, Chintamani Bhuiya has given first preference to Nabrangpur, and there are also 29 other districts preferences available to him. His social categories SCBC and gender, male. His total score is 147.482. Your lordship may kindly note that score. The last candidate of SCBC open means male and female taken together, category in Nabrangpur district has secured a score of 167, which is more than the petitioner. Lord, am I clear, my lords?
Yes.
Now let me see what is his position vis-a-vis the state list. So therefore, his mark is 147.48. Nagarangpur, the last mark is 167. And let us see where he figures in the state list. The score of the last candidate SCBC open category science in the state is 166.453. Am I clear, my lords?
Yes.
He therefore does not fit into any place in the state because he has scored 147.48. Nabarangpur last mark is 167. In the state, it is 166.453.
Yes.
Now, let me see, my lord, how does he fare in category 2 science? Because he has applied for both the streams. Now, if your lordship sees B, my lords, Chintamani Bhuya has also applied for category 2 science. And he has given his first preference to Malkangiri. Kindly see a person from Cuttack. For one stream, he says, give me Nabarangpur. For another stream, he says, give me Malkangiri. And let us see how he fares there. Lord, may I place it?
Yes.
Category 2 science has given first preference of Malkangiri, and there are also 29 other district preferences available for him. His social category is SCB gender male. His total score is 150. The last candidate of SCBC open category in Malkani district has secured 171.
Yes.
And my lord, the score of the last candidate of SCBC open category in category 2 science in the state is also 171.50. So not only does he qualify for what he had applied for, he does not fit into any other place in the state also, based on his marks. And there are Jitu Nayak, I need not read them, they are all of the same. Now, my lords, category 1 and 2. My lord, he has applied for category 1 and category 2. These are the two lists for the whole state. And obviously, his name will not figure because he is not in the marks. It is nobody's case that we were a part of the list which was prepared post CBT and we have not been considered. Right? Well, I'll just trouble your lordship with a few more documents and then straight away I'll come to judgment. Yes.
Yes.
My lord, this is just to demonstrate. So your lordship may see the first page is Nabarangpur. Nabarangpur, my lord.
Yes.
Yes. My lordships have it, my lords. Nabarangpur, as your lordship just saw, my lord, 167.315 was the last mark. Kindly see page 1. It has 21 numbers, my lords, page 1.
Yes.
Page 1, if your lordship sees, my lord, there are 21 candidates because Nabarangpur had 21 vacancies. Now the last one is 16.315, which your lordship just saw in that affidavit. And his score was 147. Now, if my lords kindly, and your lordship may see, my lords, in this list, at serial number 18, there is one Keonjhar. Right, my lords? There is one Keonjhar, 3 from the bottom.
Yes.
And he came into on the basis of merit. Now kindly see, my lords, what happens post the judgment. If I take all Nabrang, which is what I was told to do take it district-wise irrespective of the mark. Here also, if your lordship sees, my lords, post-judgment, the last candidate secures 160.118. This is page 2. The last person in this list of Nabrangpur is 160.118. Now, two things happen.
So this is post-judgment.
Grateful. Now, two
Page
things
2.
happen here. It drops from 167 to 160. Your lordships had seen the previous page. The last candidate on merit had 167.325 marks. And here it is now dropping to 160. And here also he doesn't qualify.
No, but why this was there? Keonjhar and Mayurbhanj.
My lord, Mayurbhanj and Keorbhanj, they came because they were qualifying on the basis of merit. Am I clear, my lords? Because on merit they came into that. They did not qualify their preference, but because of the marks they came here. Second preference was this place. Now the petitioner in the first one, he didn't even qualify because his mark was only 147. If your lordship looks at the next chart, which is based on only district preferences, as directed by the learned single judge.
So this can be a situation.
Yes, my lords.
Where this person, Keonjhar,
Yes, my lords.
he was not getting his
Keonjhar.
position in Keonjhar.
Keonjhar. So he came
It
here.
is first preference.
I'm grateful.
But because of his merit position, he was qualifying
I'm grateful.
as per his second.
Because he gave 29 districts, all 30. So he came here. Now, when I do the next exercise, post-judgment, only on the basis of districts, forget merit. Kindly see, my lord, same 21 posts, all Nabrangpur. The first one is, my lord, let me go a little slow. Serial number is 1 to 21, same. Extreme left-hand side column, my lord. And then kindly see, my lord, application number, roll number, name of the candidate, father's name, etc., my lord. And kindly see the last column, marks in CVT. Now, district preference, first preference district. So now we are not going by the CBT. We are restricting it to districts only. If your lordship sees that, the last person, serial number 21, he secures 160 marks. So therefore, if I were to take all district preferences, then 160 he doesn't fit in because he has got 147.48. So therefore, my lord, the consequence is this. People from other districts who are more qualified now go out of the list. And in any case, the petitioner does not fit in. I'll take your lordships to one more chart. And that your lordships will see. He also applied for Malkangiri, as I read to your lordships. Kindly see, my lord, page 3. Malkangiri, page 3, originally, my lords, the last cutoff mark is 171.500. That your lordships will get at page 3. And that will be, my lords, serial number 16.
Yes.
And my lord, your lordship will see 17 and 18 are persons with disabilities. So therefore, the last SCB mark was 171.500 and the petitioner had scored 150 marks. 150.5. So therefore, he does not get into this also. Now kindly turn over the page, my lords. Here now we are saying,
For Malkangiri.
yes, my lord.
There was only one candidate
Yes, my lord.
whose first preference was Malkangiri
And who got?
and who got.
Grateful. I'm grateful. Now kindly turn over the page. We go for all Malkangiri. Now post judgment, I don't go by what marks you have secured. I will first give all first preference Malkangiri. Now, my lord, here what happens, your lordship may see the previous page, the last mark was 171.500. Am I clear, my lords?
Yes.
Kindly turn over the page. Post judgment, the last mark goes to 144.617.
167.
I'm sorry, I'm grateful. My lord, 167, which is a drop of almost 27 marks. And the petitioner has secured 150.5. So your lordships will ask me, my lord, then why he is not there in the second list? Because he has got in UR. Kindly see, my lords. The UR list is at page 5.
Page 5. Page 5. This is already processed.
Yes, my lord. Page 5 is UR for Malkangiri already published. My lords have it, my lords. And kindly see, my lords. Page 8. My lords have page 8, my lords. So that is the end of that list.
Yes.
It has almost 79 candidates. So if your lordship sees, my lord, item serial number 79 at page 9, the cutoff is 175.904. My lordships have it. Last but one. This is the UR list for Malkangiri. His position is 79 and the cutoff mark is 175.904. Am I clear, my lords?
Yes.
Kindly now see what is the UR list post judgment. Post judgment. And if that list starts at page 9 and kindly turn to, my lords, page 13. Serial number 70.
Yes.
Now the petitioner is at page serial number 70. His mark is 150.5. This is post judgment. And if my lords are kindly pleased to turn over the page, my lords, page 14, the last mark of UA, of UR is 147. So, my lord, it now drops from 175 to 147. 28 marks. And that is how he gets in. The submission to your lordship is this. Are the children not entitled?
No, that is not the question.
Yes, madam. I'm great.
Advocate General, the question is,
Yes, madam.
there can be two types of selection.
Correct. No difficulty.
One district-wise and the other combined. So if in the advertisement it is mentioned that the selection shall be district-wise.
Yes, madam.
So if the candidates are to apply against a particular district, or then probably the judgment may be correct. That because he had applied against that district, so his merit is to be considered against that district only. No, here is a combined competitive examination. A total merit list is to be prepared.
I'm grateful.
And thereafter, based on preferences,
I'm grateful.
they are to be allotted districts. This is your submission.
And to add one more line, my lords, when he applied also, he gave a preference of 30 districts. Because he was also conscious that if I don't fit in one, I'll fit in one of the 30. But he would fill in one of the 30 if he qualifies in the test. If he is not there, if he is not there in the computer-based test list at all, then can he be considered for any district? That's the point.
No, every candidate who applied,
Yes.
was entitled to be considered for all districts against which he had given preferences. First, second, third, or fourth,
Correct,
whatever.
correct.
This is your,
Provided he qualifies. In
yes,
this-
provided he qualifies,
Yes.
then he has to be considered for all the districts for which he had given
Correct.
preference.
Show me, quick. Just a repetition, sir, 30. Let's show me that page. Page 40 of the writ petition. I don't know if the paper book will be with your lordships. Achhi ki?
Annexure 8.
978 writ petition. Achhi ki?
Annexure?
I got the copies, can I pass them?
The writ petition we have.
Ah, yes, the annexes they have not given, it is with annexes. If my lord what I.
Oh, annexure, acha, writ नहीं है.
The writ petition I have.
You can see this.
This is the writ petition I have got copy for my.
This is the document my learned advocate general is like.
This is part of writ appeal.
Yes, in the part of the writ petition. Out of which this appeal arises. And kindly see page 40. This is annexure 3 series. To the
Yes.
writ petition.
Yes.
Your lordship may see, this is the candidate about whom we are discussing, Chintamani Bhuiyan. Your lordship may see application number on the right side is Chintamani Bhuiyan. My lordship have it, minutes. Now let us see what he does. Father's name so and so, mother's name so and so. City preferences, Bhubaneswar, where he will give his exams. Bhubaneswar, Cuttack, Jagatsinghpur, Nayagarh. Kindly turn over the page. District preferences for joining. My lordship's have it, minutes. So therefore, it is not his case that I only applied for one district.
Nabarangpur, he has given first preference.
First preference. I am grateful because he was aware that based on the CBT test, if he qualifies, he has to not give only one. He has to give several. And he gave all 30. So my submission to your lordship is this. He has to first get into the CBT test qualification. After he is shortlisted, his district will be organized depending on his preferences. That's all. Now, my lord, I will show your lordships a few judgments and I'm done. Can't do it. I'm sorry. This can't happen every time. My lord, lordship may see. My lord, this was a case regarding filling up of medical posts. And this is 1968 2 SCR 786. This is a constitution bench judgment. So here, the allocation was something similar to us. There was a rule 8, which said it will be district based. And kindly see paragraph 2 minutes at page 2 of the judgment. Your lordship have paragraph 2. Rule 8, which is another rule under challenge, provides that the seats reserved in the general pool and seats reserved for the socially and educationally backward classes will be allocated among the various districts on the basis of ratio of population of each district to the population of the state. My lordships have it based on districts. Now, my lords may kindly turn to paragraph 9, which is at page 5, because they are dealing with the validity of this rule. Paragraph 9, my lord. At page 5, my lords have para 9.
Yes.
The next attack is on rule 8, which provides for a district-wise distribution of seats according to the population of the district, this is attacked first on the ground that it violates Article 51. My lord, I will not read this because they have not agreed with this attack. If my lords kindly turn over the page, my lords, they say 15 is not violated. Let me straight away go to para 10. My lords have para 10, my lord. In the alternative, it is urged that district-wise distribution violates Article 14 of the Constitution because it denies equality before the law or equal protection of the laws, in as much as such allocation of seats may result in candidates of inferior caliber being selected in one district, while the candidates of superior caliber cannot be selected in another district. Exactly what your lordships are seeing in this case. Somebody with a higher mark is going out and somebody with a lower mark is getting in. Let me read further.
No, this can happen.
Yes, well.
This can happen if you have one combined selection.
For one district.
No, for all the districts.
Correct.
You have combined selection.
Yes, well.
But in the advertisement,
Yes,
you
sir.
point out
Yes, well.
that you can apply against this district.
Correct.
One can apply against this district. Then the selection process for that district is confined to one selection process.
Correct.
Though your selection process
Correct.
is combined.
Correct.
So this can happen.
Yes, well. Let me read further.
Yes.
One is so and so. It has not been denied on behalf of the state that such a thing cannot happen, though there are no statistics available in this behalf because the mark sheets were all destroyed after the interviews. Para 11. The question whether district-wise allocation is violative of Article 14 will depend on what is the object to be achieved in the matter of admission to medical colleges. Here, your lordship may read it, my lord, for selecting teachers to teach. The object of selection can only be to secure the best possible material for admissions to college, subject to the provision for socially and educationally backward classes. So this is the rider. Further, whether selection is from the social and educational backward classes or from the general pool, the object of selection must be to secure the best possible talent from the two sources. If that is the object, it must necessarily follow that the object would be defeated if seats are allocated by districts allocated district by district. It cannot be and has not been denied that the object of the selection is to secure the best possible talent from the two sources so that the country may have the best possible doctors. If that is the object, the argument on behalf of the petitioner appellant that it is the object cannot be possibly be served by allocation district-wise. It is true that Article 14 does not forbid classification, but classification has to be justified on the basis of the nexus between the classification and the object to be achieved, even assuming the territorial classification may be a reasonable classification. The fact, however, that the classification itself is reasonable is not enough to support it unless there is a nexus between the classification and the object to be achieved. Therefore, as the object to be achieved in a case of the kind with which we are concerned is to get the best talent for admission to professional colleges, the allocation of seats district-wise has no reasonable relation with the object to be achieved. If anything, such result will result in many cases in the object being destroyed. And if that is so, the classification, even if reasonable, would result in discrimination in as much as better qualified candidates from one district may be rejected, while less qualified candidates from other district may be admitted from their own two sources, from either of the two sources. So they have gone really one step forward, my lords, to say that such a rule also will be frowned upon. Kindly turn over the page, my lords.
Yes.
Lords, you may see, my lord, there is one line which starts after 7-8 lines. We are also satisfied. 9th line, my lord. We are also satisfied. My lordship shall have that line. We are also satisfied that such allocation results in discrimination and there is no nexus between the territorial distribution and the object to be achieved, namely admission of the best talent from the two sources already indicated. We are therefore of the opinion that allocation of seats on the district-wise basis is violative of Article 14. We may add that we do not mean to say that territorial classification is always bad under all circumstances. But there is no doubt that district-wise classification, which is being justified on territorial basis, in these cases is violative of Article 14, for no justification worth the name in support of the classification has been made out. We therefore hold Rule 8 providing district-wise allocation is bad as it violates 14 and therefore we struck it. So they say that rule said district-wise. They said, look, you are looking for the best talent. So you can't say that district-wise or territorial-wise.
No, but this was whether on the basis of residence of a particular candidate.
Correct.
Here,
Yes.
A resident of Khurda
Yes, my lord.
could
Could
give
apply anyway.
first preference
Yes.
for, say, Malkangiri.
Fair enough. But what they say is that when you are selecting an MBBS student, select the best talent. Don't restrict it to any district. Here I am saying that if I am selecting a teacher, the students of Malkangiri, Bolangir or Khurda, any matter, any district, they should have the facility of getting taught by the best. That is why you had a CBT exam, otherwise there was no reason. Now, this is one. Kindly see one more judgment. Now, this is Radheshyam Singh, where a zonal consideration was being considered. People were applied, so they said, okay, for A zone, these candidates. Kindly see para 2 minutes. May I see, Lordship, may kindly see para 3 at page 62. This is, my Lord, 1997, volume 1 SEC, page 60. And if my lords are graciously pleased, my lords, kindly turn to paragraph 3, my lords. My lords are para 3.
Yes.
According to this said advertisement, recruitments were to be made zone-wise on the basis of a separate merit list drawn from each zone in respect of the candidates who appeared at the centers within the same zone. The relevant portion of the said advertisement, which relates to zone-wise process of selection of candidates for the said post, as stated in para 16 of the advertisement, for ready reference is reproduced. Your Lordship may skip all that, minutes, and kindly come to paragraph 7. This is just above placitum H.
Yes.
The question, therefore, arises for consideration is whether such a selection based on zonal basis would be permissible or would it violate the constitutional guarantee enshrined under 14 and 16 of the Constitution of India? This is the question, my lord, the Honorable Supreme Court poses for itself. Now, paragraph 8. It is needless to emphasize that the purpose and object behind holding a recruitment examination is to select suitable and best candidates out of the lot, and such an object can only be achieved by making a common select list of successful candidates belonging to all zones. On the other hand, if zone-wise selection is made, then various candidates who appeared in some of the zones and secured more marks than those who secured from other zones would be deprived of their selection, resulting into great injustice and consequent discrimination. Thus, there can be said to exist no nexus between the aforesaid process of zone-wise selection and the object to be achieved, that is, selection of the best candidates. That being so, the process of selection envisaged in para 16 of the advertisement in question and reproduced in the earlier part of the judgment would lead to discriminatory results, because adopting the said process, zone-wise selection would result in devaluation of merit at the selection examination by selecting a candidate having lesser marks over the meritorious candidate who has secured more marks, and consequently the rule of equal chance for equal marks would be violated. Such a process would only be against the principles enunciated in Article 14 and 16 of the Constitution, but it also result in heartburning and frustration amongst the young men of the country. The rule of equal opportunity, Your Lordships have read it, and then I need not trouble Your Lordship. My Lord, one more judgment and I'm done. My Lord, this is 2021 4 SCC 542. And there is a concurring judgment.
Which volume?
My Lord, this is 2021 volume 4 SCC 542.
Yes.
This is Saurav Yadav and others versus State of Uttar Pradesh. And if my lords are kindly pleased, this is Justice Bhatt's concurring judgment. And it is at page 590.
Yes.
Paragraph 38 and 39. The second view is thus neither based on the authoritative pronouncement of this court, nor does it lead to a situation where merit is given precedence. Subject to any permissible reservation, either social, vertical, special, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidates getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensations when it comes to candidates being considered against seats or quota meant for reserved categories, and in the theory, if it is possible that more meritorious candidates coming from open general category may not be selected. But the converse can never be true and will be opposed to the very basic principles which have all the while been accepted by this court. Any view or process of interpretation which will lead to incongruity, as highlighted earlier, must be rejected. The second view thus, para 39, the second view thus will not only lead to irrational results, where more meritorious candidates may possibly get sidelined, as indicated above, but will of necessity result in acceptance of a postulate of open/general candidates or reserve candidates other than those coming within the vertical. So I am relying on the first line, and that's it, my lords. I'm grateful to your lordships. Yeah, please.
Lordships, we've been like greatly benefited with the Honorable AG's argument, not much to add except this, that which in fact fell from your Lordship's mouth also, is that this was never meant to be actually a district-wise or a residence-based recruitment.
See, there could have been two results. One, purely based on the merit for the entire state, based on preference also. And then that one merit list would have been bifurcated, divided, again based on preference. So there would be no difference between the first merit list, the candidates in the first merit list, and those selected, those divided, bifurcated from them based on preference, district-wise. Am I clear?
Lordships.
So only a separate merit list, like it's a kind of allocation to districts.
Lordships.
So one from one combined merit list, you are allocating, the state is allocating different districts.
Yes, and I think one thing which I wanted to bring to your Lordship's notice is this, that each one of them was actually allowed to participate for each and every post, irrespective where it is placed. That's very important. All that probably the state did, instead of state preferring, you are allocated this or that, allowed that you make your preference or your first or second preference wherever you want to be placed according to the marks that you secure. So state never wanted to do away with the merit issue. So that's very important, because when it happens, if it was completely district based, then in fact they would have also asked for a residence certificate or something. That was not at all the case here. So
No, residence was never the criteria.
never the criteria.
Reference had some criteria.
Criteria. And according to your preference, you do get allocated. That's all. But this preference was never meant to absolutely not allow people who are higher up in the merit to go away. Because as I last time also submitted, the extreme of that argument would be that only because I preferred, I'll get a seat even if I secure 0. But that's possibly not. And I think that would be a very compromising situation vis-a-vis the state, and state would vis-a-vis the districts, which state would never want to do. Especially if you want to maintain a particular standard of education throughout the state. That's all would be to look at the entire thing from that perspective. That's all I would add. Otherwise, everything has been covered by a honorable.
May be permitted to supplement Land Advocate General. So I'll only supplement by some 2-3 judgments. But one thing, as your lordships pointed out, so far the merit of the case is concerned, in fact, on 10/9/2023, which was placed by the Land Advocate General, the candidates will be selected on the basis of the marks secured on the CBT computer-based test examination. This was circulated about the candidate, and candidates are aware before the process of selection was started, before the CBT exam.
There is another aspect.
Sir.
The notice, the advertisement was not contrary to any provision under the resolution.
Under reservation.
Under resolution.
Oh yeah, resolution.
The resolution. So that the process which was adopted was not in conflict with any provision under the resolution 8.2, 8.3.
Right,
whatever.
right. So therefore 8.2 read with this notice dated 10/9/2023 makes it very clear. The candidates will be selected on the basis of the marks secured in the CBT computer-based test examination. That's all. And the lordship already read 8.2 and 8.3. What comes to my mind?
And the district-wise posts were not advertised.
No, sir. The according to my submission, yes, according to my submission, 8.2 is the preparation of the merit list through the computer-based test, and the allocation is 8.3, if I have correctly understood. And the what comes to our mind that here is a question of merit and the preference of the district. This comes to 2 things. So I have brought 2 judgments. Here is a case. AI 2006 Supreme Court, because I don't want to again further add something which Land Advocate General already clarified to your lordships. And they have given also illustrations. And this judgment, if your lordship will come to where the merit and the preference is there, particularly which will be preferred. Lordship, look to paragraph 4. Paragraph 4. To appreciate the real controversy in perspective, it is necessary to notice the requisite qualification mentioned in the advertisement as per the requirement of Rule 8 of Uttar Pradesh Homeopathic Medical Service Rule 1990. These are the academic qualification, the entry, the recognized degree in homeopathic, that is the minimum qualification. But you'll also see the bottom. It will be noticed from the above quoted rules that in addition to the requisite qualification, a proviso has been added, inverted comma, preference will be given to the degree holders. The real controversy starts from the proviso that preference will be given to degree holders. Then also straightway come to the last but one page, the judgment in 2003 BB Commission versus YBBR Srinivasan that has been quoted. Let me read that quotation, then I'll take your lordship to paragraph 12. The word preference.
Which paragraph?
Well, that is paragraph 11.
11.
Just above paragraph 12.
Yes.
The quotation. The word preference, in our view, is capable of different sets of meaning, taking color from the context, purpose, and objects of use on the scheme of things envisaged. Hence, it is to be construed not in isolation or detached manner, ascribing a meaning of universal import for all contingencies capable of an invariable application. The procedure for selection in case involves a qualifying test, a written examination, an oral test or interview, and the final list of selection has to be made on the basis of the mark obtained in them. The suitability and all-around merit it has to be adjudged in that manner only. That justification could be there for overriding all these merely because a particular candidate is in possession of an additional qualification on the basis of which a preference has also been emphasized. The rule do not provide for separate classification of those candidates or apply different norms of selection for them. The preference, inverted comma, emphasized in the rule, in our view, under the scheme of things and contextually, also cannot mean an absolute en bloc preference akin to reservation or separate and distinct method of selection for them alone. A mere rule of preference meant to give weightage to the additional qualification cannot be enforced as a rule of reservation or rule of complete precedence. Such a construction would not only undermine the scheme of selection envisaged through the Public Service Commission on the basis of merit performance, but also would work great hardship and injustice to those who possess and the required minimum educational qualification with which they are entitled to compete with those possessing additional qualification too and demonstrate their superiority merit-wise and their suitability for the post. It is not to be viewed as a preferential right conferred even for taking up their claims for consideration. On the other hand, the preference emphasized has to be given only when the claim of all the candidates who are eligible are taken for consideration and when anyone or more of them are found equally positioned by using an additional qualification is a titling factor in their favor vis-a-vis other in the matter of actual selection. Then paragraph 12. In the instant case, the requisite academic qualification for the post of homeopathic as prescribed in the advertisement was recognized a degree in homeopathy or a recognized diploma in homeopathy. A proviso has been added that the preference will be given to the degree holders. This would mean that a recognized diploma in homeopathic prescribed in the advertisement is also a required minimum educational qualification with which they are entitled to compete with those candidates possessing the degree. The word preference would mean that when the claims of all candidates who are eligible and who possess the requisite educational qualification prescribed in the admission are taken for consideration, and when one or more of them are found equally positioned, only the additional qualification may be taken as a titling factor in favor of the candidate vis-a-vis others in a merit list prepared by the commission. But preference does not mean en bloc preference irrespective of inter se merit and suitability. This is one.
Mr. There is difference between the preference which has been dealt with in this judgment and the preference in the present selection process.
Yes.
There, the preference, the selection body gives.
Right.
The state
Because
gives.
of the degree.
State gives that preference. Here, the preference is to be given by the candidate.
Yes, sir.
For the purpose of allotment of a district.
Allotment
This
of a
is the
district.
difference between. But yes, the law, the crux remains that merit has to be given.
Merit has to be given. That is what my entire.
But the preference in this and preference.
Is absolutely correct. Absolutely correct. There the state has done it or the employer has done it. Here the candidate themselves have done it.
Have to prefer.
Prefer.
They have 10 choices.
Yes, sir.
Which will you prefer?
Right, sir. Right. So now the question is, sir, the merit. Merit cannot be sacrificed. And I don't know, possibly it is for the state. So far 8-2 is concerned, they have prepared a list. So far as these 4 candidates who have approached this honorable court, whether their names at all found place in that merit list that was just prepared in terms of Rule 8-2, I don't think. And even if their names found place, even if their name must be below that list. So they cannot be compared to a person. But I just give an example. Suppose the district Khurda, there are only 10 posts and 30 candidates have given their preference to Khurda district. But it is the employer's duty, the state duty to give those candidates according to that preference. They will give the other candidates which cannot be accommodated as per their merit to other district. So therefore, under no circumstances merit can be sacrificed. The
No,
merit is,
there can be another example.
sure,
I don't know the this thing demography and the economic conditions, but suppose Kalahandi.
yes, sir.
So for Kalahandi, the first preference is made by say 20 candidates only out of 1 lakh. So
Right.
can it be a situation that those 10 candidates will have to be selected for Kalahandi, whatever their
Right.
performance is?
Absolutely, absolutely right. Your also is correct. Correct. That is the position. Cannot. So therefore, the has to be the merit list cannot be ignored. So far as the post judgment is concerned, what they have prepared, I found these 4 candidates, even including the petition number 1, the private opposite party, they have secured the marks much below the marks secured in the last candidate in any other districts. So the category 2. So for the Malkan, in that case, if the honorable single judge judgment is accepted, that means a candidate who has secured 146 has to be selected, and a candidate who has secured 176 has to be ignored. That means in between 2, the merit has to be sacrificed. That is what another judgment I'm just giving. I close my argument. This is also 1989 Supreme Court page 1194, paragraph 14. I think Advocate General cited one judgment also that that's the intelligible indifferentia so far as this district is concerned. That paragraph 14. Let us now examine the question of college-wise institutional preference, paragraph 14. From the point of view of Article 14 of the Constitution, by the impugned rule, a classification.
You are reading which paragraph?
Paragraph 14. Paragraph 14. 1-4.
Yes. Please.
Let us now examine the question of college-wide institutional preference from the point of view of Article 14 of the Constitution. By the impugned rule, a classification is sought to be made with the students of each particular college passing their MBBS examination from that college to the exclusion of all other students obtaining their MBBS degree from the other colleges. In order that a classification is a permissible one within the meaning of Article 14 of the Constitution, 2 tests have to be satisfied. Namely, 1, that there is an intelligible differential which distinguishes persons grouped together from those who are left out of the group. 2, that there is a rational nexus to the object sought to be achieved by the impugned rule. The object sought to be achieved by the impugned rule is obviously to prefer merit for the postgraduate course and to exclude less meritorious candidate. Then you also kindly come to paragraph 15, middle portion. Paragraph 15, middle portion. Thus, although you also from paragraph 15, 1, 2, 3, 4, about 8 lines from the top. Thus, although Dr. Anjali Swansu and Dr. Sumit Swansu secured more marks than the student admitted in the postgraduate course in Swansu in said GS Medical College, except the said Dr. Ganapati Sawan, they refused admission in view of the college-wise institutional preference. Similarly, in respect of other discipline, many meritorious students could not get admission even though they secured higher marks than those admitted in the postgraduate degree course by virtue of the impugned rules. Thus, there is a patent discrimination in as much as the students obtaining lesser marks have been preferred to those obtaining higher marks. There is no intelligible differential for the classification by way of college-wise institutional preference as provided by the impugned rule, distinguishing the preferred candidates in respect of each college from those excluded from such classification. By such classification of college-wise institutional preference, merit has been sacrificed. Far less it has been preferred. When the university is in the same for all these colleges, the syllabus, the standard of examination of a skip over, last line. In such circumstances, college-wise institutional preference cannot be supported. And it has already been noticed that this court has not approved of such preference at all. These are so far the merit is concerned. Well, I have already argued before the Law and Advocate General has argued. So far as the implicit of party is concerned, I have already argued. One judgment I will show you, even the Honorable Supreme Court has gone to an extent that if a person is a necessary party but has not been included as a party, then that judgment is ab initio void. That is null and void. That is that is a judgment. Kulwant Singh's case, which has been referred to by a division bench of where my Justice Sharangian just that judgment I'm not giving, but the Supreme Court judgment I'm giving at paragraph 39 and 40. Copy. Yes. Yes.
That is order in SLP. Kulwant, right?
No, it is, yes. But Supreme Court in civil appeal. In a civil appeal, yes. Civil
It's
appeal.
not a judgment. Order in SLP, that is referred to. Judgment.
No, this judgment, if your lordship will look to, just I'm showing it, para 39. Para 39. If your lordship will look to that para 39.
Yes.
But you lordship note that L. Chandra Kumar case has been referred to.
Yes.
First, we look at the facts of non-impletion, which was been highlighted by Mr. Gupta. The said submission has two limbs. First, the mere awareness of the pendency of litigation because it is mentioned subject to the decision of the original application does not make the order binding upon him. And the second, by the time the judgment date was pronounced, all the respondents were sent for lower school courts and promoted, and therefore they are clearly identified as ultimately affected parties. Hence were necessary parties for the purpose of adjudication of the lease. Para 40. At this stage, we shall notice certain authority which have been commended to us for adjudicating the effect of non-impletion of party. In Khetrabasi Biswas case, let's skip over that case of Orissa. You'll also skip over to next page.
Yes.
Next page. The appellates who had come to this court were not parties to the writ petition. The High Court, while preparing its own list, did not think it fit to issue notices to other candidates like the appellant before this court, who has suffered prejudice by the regions of the directions issued by the High Court. While dealing with the justifiability of the same, this court held that they were necessary parties. In that context, expressed thus quotation: the procedural law as well as the substantive law both mandates that in the absence of a necessary party, the order passed is a nullity and does not have a binding effect. The other judgment I have already given. I did not take your lordship so much time. I'll only give a memo of citation and I'll give to your lordship. That's my.
Yes.
The small petition from my lordship. Since learned Advocate General and all other senior advocates, they have placed their submission. I'll not take much time of my lord's lord. Limit it to only 2-3 points.
So we'll come back within 2 minutes.
Right, one SEC. I'm giving that book. My colleague is giving. Yes.
Locus, why?
The reason being, from the charts demonstrated by the landed Advocate General, either way, if it's a district-wise selection,
The question of locus can be referred to at the time of presenting the application.
correct, my lord.
So at the time of presenting the application, they had the locus because they were questioning the process of selection,
They were
the result.
regent, not the process. Process, they had a locus.
No, process, no, they had challenged the result.
Right.
The result in which their names did not figure. All right, they questioned the result in which their names did not figure in respect of a selection process in which they had participated.
Correct, my lord.
Locus, you may say that after, so whatever the
result has come out.
done, the merit
Now,
list, and then the
You did not
district
have
is
any more
also-
cause of action. You did not have any more cause of action because your name doesn't figure in the merit list either way, either district-wise or state-wise. Keeping those charts in view, those demonstrating.
Locus, you may say that in view of these two demonstrations,
Correct.
they do not have any case.
So grateful.
So there was no
So grateful.
No reason for
Approaching them
interference.
before the High Court.
No, approaching they had,
Correct.
but there was no requirement of interference.
Right. my lord.
So
Ah, jealous.
That you may say.
That's right.
Locus,
Page 34.
yes.
Book is that. Para 34. Para 34. Para 34, my lord, that's exactly on the same line. Para 20. Your Lordship may kindly see para 28 first. In Bar Council of Maharashtra, so a bench of 7 learned judges of this court considered the question whether Bar Council of a state was a person aggrieved to maintain an appeal, so and so, so and so. The meaning of the word a person aggrieved may vary according to the context of the statute. One of the meanings is that a person will be held to be aggrieved by a decision if that decision is materially adverse to him. Normally, one is required to establish that one has been denied or deprived of something to which one is legally entitled to in order to make a person aggrieved. Again, a person is aggrieved if a legal burden is imposed on him. Meaning of the word a person aggrieved is sometimes given a restricted meaning in certain statutes, which provides remedies for protection of private legal rights. The restricted meaning requires denial or deprivation of legal rights. A more liberal approach is required in the background of statutes which do not deal with property rights, so and so on, morality. The role of the Bar Council of Advocates Act is comparable to the role of guardian in professional ethics. Word person aggrieved, section 37-38 of the Act are of wide import and should not be subjected to restricted interpretation, possession of denial of a legal right, or burden financial interest, etc. Now, your Lordship may see para 34. Para 34. This court has laid down in a number of decisions that in order to have the locus standi to invoke the extraordinary jurisdiction under Article 226, an applicant should ordinarily be one who has a personal or individual right in the subject matter of the application. Though in the case of some of the writs like habeas corpus or quo warranto, this rule is relaxed or modified. In other words, as a general rule, infringement of some legal right or prejudice to some legal interest inhering in the petitioner is necessary to give him a locus in the matter. So and so, the judgments.
Yes.
Lord, I stop it on the question of locus here, my lord. Now, your Lordship may say with regard to non-impletion of party, my learned senior Mr. Rautra has placed judgments. Lord, I have only a supplementary judgment to that effect. 2020, volume 2, SEC, page 173. Para 72 straightway.
2020 volume.
2020, 2 SEC, page 173. Para 72. I've given a copy for my lord's convenience.
Yes.
Para 72. When the selection of successful candidates is challenged,
Yes.
when the selection of successful candidates is challenged, depending upon the facts and circumstances of the case.
Which paragraph?
Para 72, Lord. I'm so sorry. Para 72.
Yes. Yes.
When the selection of successful candidates is challenged, depending upon the facts and circumstances of the case, the successful candidates ought to be put on notice about filing of the writ petition by impleading them by issuance of notice in accordance with law by Pune versus State of PP. In the present case, we are not inclined. The Honorable Supreme Court was not inclined to accept that because they were put to notice. The successful candidates are put to notice. That is why the Honorable Supreme Court has said, but has laid down the law, well-established position that they are bound to be implemented as parties and put to notice.
Yes.
Here in this case, not a single successful candidate was implemented as a party, nor they were put any notice. And coupled with the other judgment, a decision rendered without implementing a necessary party, a person as a party is void ab initio and not binding on them. Now, my Lord, my third contention before my Lord should be, if your Lordship would see page 99 of my brief, my Lord. Lord, which correctly fell from my Lord's mouth. Kindly see, my Lord, that whether this is selection is state-wise or district-wise. It is one thing to say that selection is state-wise or district-wise and allocation of vacancy to the districts for the purpose of appointment from the common list. Am I clear, man? Now, if your lordship sees that the cost of repetition, page 99 of my brief may vary in the other brief, my lord. Just one line I'll paste. The candidates, Lord,
Which appeal?
Lord, this is writ appeal 740 of 2024. How to call judgment?
740.
Right, my lord. So my writ appeal is 740 of 2024.
Yes.
Page 99.
Annexure.
But annexure, this is Lord, annexure 2 of the writ petition, my lord, before the honorable Singh judge. Running page 99.
Got it.
That is the advertisement.
Yes.
Lord, that is the advertisement forming basis of all these people to apply and get their selection mark. Lordship sees in the second paragraph from the bottom, the candidates will be selected.
Yes.
The candidates will be selected on the basis of marks secured on CBT computer-based test examination.
Yes.
The syllabus of CBT examination is available in OSEPA website. The date, time, exams, CBT is not very relevant. So what the advertisement itself said, that the candidates will be selected based on CBT examination. Advertisement do not say there will be district-wise selection. Never says that. Next, my lord, to avoid that confusion, whether the district-wise selection or district-wise vacancy. Kindly see the next page, my lord. Kindly turn to the next page, page 100. I'll demonstrate it from this document, my lord. This is a part of the document filed by the petitioner himself.
Yes.
Lordship will see the district-wise vacancies are indicated here over this page. So obviously, the authority never meant that there will be a district-wise selection, but allocation district-wise will be there.
Yes.
Now, Lord, coming to the next point, Lord, anticipating that they may try to put forth a case that district-wise selection will have a preference over merit. That they may say, referring to a particular clause in the advertisement, in the resolution, they may say that. Kindly turn to that page, my lord. That is clause that very 8.3, page 92 of my brief, man. Page 92, clause 8.3. Lord, at best, they may raise this issue before your lordship, saying that the district-wise list will have a preference over merit. A sentence is there. That is towards last of this page 93. Lord, let me place it. Clause 8.3. District-wise and category-wise draft merit list will be published. Let's got it.
Just a minute.
I'm so sorry.
Yes.
District-wise and category-wise draft merit list will be published. This is post 8.2, post computer-based test. District-wise and category-wise draft merit list will be published in OSEPA website. Draft merit list will be prepared, taking into consideration all district preference submitted by individual candidates in order of preference, followed by merit rank, that is for a particular district. After exhausting all candidates having first preference, subsequent preferences will be considered. In case of a tie, this is relevant. I'm trying to emphasize this. In case of a tie, that is, when two or more candidates obtain equal score, inter-se merit of such candidates shall be decided in the order as mentioned below. Lord, Roman 1, 2, you may skip over. Last sentence. For a particular post in a category within district, district preference will be preferred over merit. Let there be no confusion on this, that this is a clause to meet the contingency of a tie inside the district, not affecting the state-wise merit list based on CBT test. Am I clear, my lord?
Yes.
This particular sentence is intended to meet a contingency which arises on account of a tie among the candidates inside the district.
Yes.
not affecting the merit list in the CBT test. Now, my lord, I'll cite one judgment, merit cannot be sacrificed. Lot many judgments have been placed, my lord. One judgment only on that line. 2013, volume 14, SCC, page 623, para 14 and 15.
2013.
2013, volume 14, SCC, page 623, para 14 and 15. You, my lords, may straightway come to para 15. Another witty reason.
Para?
Para 15. my lord.
Yes.
Another witty reason given by the High Court in the instant case while approving the aforesaid action of CCI is that the intention of CCI was to get more meritorious candidates. There was no change of norm or procedure and no mandate was fixed that a candidate should secure minimum marks in the interview. In order to have meritorious persons for those posts, fixation of minimum 65% of marks for selecting a person from OBC category, minimum 70% mark for general category was legitimate, giving a demarcating choice to the employer. In the words of the High Court, in the case at hand, as we perceive, the intention of the Commission was to get more meritorious candidates. There has been no change of norms or procedure. No mandate was fixed that a candidate should secure minimum marks in the interview. Obtaining 65% marks was thought as a guideline for selecting the candidates from the OBC category. The objective is to have the best hands in the field of law. According to us, fixation of such marks is legitimate and gives demarcating choice to the employer. It has to be borne in mind that the requirement of a job in the competition commission demands a well-structured selection process. Such a selection would advance in the cause of efficiency. Thus, scrutinize, we do not perceive any error in the fixation of marks at 65% by the commission, which has been uniformly applied. The said action of the commission cannot be treated as illegal, irrational, or illegal.
Yes.
But that's all, Lord. I'm deeply grateful.
Yes. You have a very difficult task for the reason that you have been under attack by the Land Advocate General and senior advocates and certain observations also from the court.
But end of the day, my lords are there too.
Yes.
My lord. To start with, I am holding the brief of Learned Advocate General, WA.
No, you are not
7-1.
holding his brief.
No, because I am to refer it from that brief.
All right.
That is, because if I will make, because there are different writ appeals.
712.
Pardon?
712 of 2020.
Act. Hello, here is the case with regard to recruitment of junior teachers. Their name is now schematic. There is a history of appointment of staffs in primary school, upper primary schools. What they have done initially, that was in the Siksha Sahayak. Initially, what they have done, very past, there was direct recruitment as a teacher. Thereafter, my lord, they have changed it. They have recruited Siksha Sahayaks on a fixed tenure basis, and on completion of certain years of service, they are regularized as regular primary school teachers. Now, for the first time, they have introduced, after the Siksha Sahayak, now this time, they have stated, no, we will introduce the junior teacher. Now they are saying schematic. Under the statute also, because these appointees ultimately merges with their service condition will be guided under the Odisha Elementary Cadre Rule 1997 as it has been amended. So there is a connotation of junior teacher. Entry level, it is junior teacher. That is now, it will be level 5, 5A, 5B, 4, 3, 2, like this. That is there. With this background, we have to start. So now these junior teachers are appointed, or the Siksha Sahayak or the regular teacher, all are to be appointed in the primary schools. Primary and upper primary school, therefore there are two categories of posts. their entry into the service is in a district cadre post. That I mean to say, man. Whatever name they enter into service, they fall into a, finally they fall into a cadre, which is a district cadre post. District essentially means revenue district. We have 30 districts in the state. So accordingly, this is a district cadre post. That is why all the selection made in that. Previously, before I'm coming to this particular case, in the Sikhya Sahayak, identical problem arises.
No, but is that required? Let us confine to this problem.
Yes, my lord. No, because that is a nexus, because there is a order of this honorable court in the previous cases, identical issue, identical manner. That was the issue. I quoted in the writ petition also. That is why I want to read that order first, because that is history. When the Sikhya Sahaks were entered into services, into the district cadre post, a identical problem was also there, and it has been answered by this honorable court, by the honorable single judge, which has not been challenged and it has been acted on. So may I take my lord to that part of the order? Page 101. That is part of my writ petition. I have quoted my lord's order there.
You want us to see the writ petition?
Yes, this is part of the writ petition. It is running page 101, man. That is WPC, that is quoted, man. 3319 of 19.
But it is not there.
Yes, my lord, it is page 101, man. In the writ appeal 712.
In the appeal, it is there.
Yes.
Yes, sir, that is quoted in the writ petition. I am referring to the writ petition. Running page 101. My lord, good.
Just a minute.
Para 12. Okay.
12, that is 14. 14.
Yes.
My lord. I'm just reading out what the
WPC 3319 of 2018.
3319 of 2018, order dated 28 to 19. Or Mr. SB General and Counsel for the petitioner, Mr.
Page?
B. Mohantil and Standing Counsel for
Running page 101.
Yes.
my lord, good.
Yes.
My. Shall I read one?
100. 100.
Shall I read?
Yes.
My lord. 102. The petitioners have filed this application seeking for a direction to the opposite parties to prepare the merit list of the post of Sikhya Sahayak as per the merit issued and issue order of appointment accordingly. Mr. SB General and Counsel for the petitioners brought to the notice of the court a resolution passed by the government in Annexure 1 and submits that as per clause 4.3, selections shall be made on the merit, that is, on the basis of percentage of mark. He further referred to clause 5, that is mode of application, and clause 5.7 reads as follows. This is 5.7. District-wise, post-wise, and category-wise 100% merit list as per vacancies will be prepared by OPEPA through NIC as per district preferences submitted by the candidates and merit of the candidates. The draft will be prepared taking into consideration of all district preferences submitted by the candidates in order of preference, followed by merit, that is after exhausting all candidates with first preferred district. Second and third and subsequent preferences will be considered. For a particular case post in a category within district preference will be preferred over merit. In course of hearing, a query was made by the court with regard to the selection to be done in respect of Sikhya Sahayak as a state cadre post or WPC number 3319 of 2008 district cadre post. Mr. SB General and Counsel for the petitioner has very fairly states that Sikhya Sahayak is a district cadre post. In that view of the matter, this court is of the view that if the Sikhya Sahayak is a district cadre post, merit list is to be prepared on district wise. Even a candidate secure higher percentage of mark in postal district, he may not be given an appointment in district cadre, but a candidate who secured less percentage mark in a district cadre, he may be selected. Therefore, this court doesn't find any illegality or irregularity in the selection held by the opposite party. Accordingly, the petition is disposed of with the liberty so and so. Now, at this juncture, my lord, I will take my lord to the government resolution. Page 72. annexed to page 72. This was in respect of Shiksha Sag. Now we are in this particular selection for junior teacher schematic.
Yes.
Page 72. First paragraph, this is the subject is guideline for engagement of junior teacher schematic. This is the guideline prepared by the state for selection. Now, my lord, para 3. Para 3, my lord. In pursuant to section 23 of the SAD Act, National Council of Teacher Education NCT.
Oh, sorry.
Again,
You are referring to
72, my lord. This resolution.
Annex
72.
Annex
Annex 2.
Paragraph 3, yes.
In pursuance to 23, section 23 of the SAD Act, National Council of Teacher Education NCTE, being the academic authority, has laid down the minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8 by notification published in Gazette number 215 dated 25/8/2010, keeping in the view the provisions of the Act and the rules and the guideline issued by the National Council of Teacher Education. Government have issued the resolution bearing number so and so in supersession of the department resolution so and so, so and so. Let us keep over. Dated so and so, prescribing the guideline for engagement of Shiksha Sahayak, subsequently designated a junior teacher schematic. Now it is an access to the other case I have reported. As prescribed in the Odisha Elementary Education Method of Recruitment and Condition of Service Teacher and Officers Amendment Rule 2014, element teachers are appointed in the state through absorption of junior teachers after 3 years of continuous and satisfactory service, considering through a committee at the district level. A junior teacher schematic become eligible to be a junior teacher after 3 years of continuous and satisfactory service. Their 6 years of service, engagement, as mentioned above, will be coterminous with that of Samagra Shiksha scheme till their absorption in the regular elementary cadre. NCT have been revised minimum qualification for prescribing this level. Let us keep over next man. Now the government have been pleased to supersede the previous resolutions and have decided to conduct the recruitment for engagement of junior teacher schematic through an online computer-based test as per the detail given below. 1. That all the function of elementary education will be transferred in phases to Jilla Parishad and other Panchayat Raj institutions. That the engagement of all junior teacher schematic will be made by the respective Jilla Parishad under the each category, that is class 1 to 5 and class 6 to 8 under the program of Samagra Shiksha SS for implementation of the SAD Act for elementary education. So this is for this district. My humble submission is this is for a district, and this is appointment ultimately comes to a district cadre post, and that is why the advertisement is. Now, my lord, the mode of application is para 4. Well, one thing I will say, para 3 of the advertisement, clause 3, clause Roman 3I. Intending candidate may visit OSEPA website for further information as mentioned below. A. District-wise number of vacancies and vacancy reserved for different social category, PW candidate, ex-servicemen, sports personnel as WRVF and other prevailing act and rules. My lord have put me a question, put to them the question I was standing up, my lord have kept me mouth. That my lord's question was in course of hearing, whether there was a post advertised for each district. Yes. At this juncture, I will continue further. They have stated district-wise number of vacancies, vacancy reserved for the post are advertised. In the advertisement, if my lord will see, because that in my writ petition, I have given the vacancy position. It is test 30. Test 30. They have not filed it. In the writ petition, if my lord will see, this is the vacancy position. At the writ petition, they have not.
We are giving you an example. Suppose
My lord.
constables are to be recruited in the state.
My lord.
All right. So it's I think district, the appointing authority is superintendent of police.
My lord.
So the vacancies would be district wise.
My lord.
The vacancies.
That is why I have read only 8.1 and I have kept it paragraph 3. My lord have put a question that there is a district wise advertised vacancies. Each district, how many posts are there, that is there. So the district wise, now my lord straightway come to this paragraph 8, selection procedure, page 78. Page 78, my lord. Page 70, selection procedure has different phases, my lord. My response submission is this at the outset. What are the stages? After stage 1, stage 2, stage 3, like this, my lord, they are categorized. It is the government resolution. And the authorities are to act accordingly. So now, my lord, what is stage 1? Application intending candidates have applied for. Those who are found eligible, a list is to be prepared. My lord, kindly see stage 1. What is 8.1? Public, place 78, my lord, I'm reading. Yes. 8.1. Publication of master list. After expiry of last date of submission of online application form, comma, list of candidates for each category with respect to their first preferred district as submitted by them at the time of submission of application form will be published in OSEPA website, full stop. After these applications were submitted by different candidates, because there are 2 categories of posts are advertised as para 5. Category 1 is for class 1 to 5 and category 2 is from class 6 to 8. These are the 2 categories. One candidate also eligible for apply for both. So what the first stage says, after the applications are received, the OSEPA is to categorize the candidates on the basis of their first preference district. At that point of time, there is no examination. Well, this is the first stage. I'll be slow again. I'll repeat again. After expiry of the last date of submission of online application form, list of candidates for each category with respect of their first preference district as submitted by them at the first submission of application form will be published by the OSEPA in a website. A list of first preference candidate of each 30 district has to be published. And
You are reading which clause?
Clause 8.1, man. Page 78.
No, read it again.
My.
78.
After publication of master list, man. That is called master list.
Yes.
After expiry of last date of submission of online application form, comma, list of candidates for each category with respect to their first preference district as submitted by them at the time of submission of application form will be published in OSEPA website. The next sentence says, information on subsequent preference district of each candidate will also be available in website, OSEPA website on search. That is on search. But the thing is to be done by the authority. On receipt of the application form, they will segregate the first preference district of each candidate because there are 30 districts. Each candidate is bound to give 30 preferences, 1, 2 to 30. So suppose a candidate has given, first is Nabarangpur, let us say. All the candidates, from amongst all the candidates, whatever the application come, they will choose the first preference district so far Nabarangpur is concerned.
So therefore, we had given you this example that if there are 30 persons who apply for, say, a district Kalahandi, they give first preference. There are 30 posts and only 30 give first preference. Then those 30 are to be selected.
That is the scheme.
That is
the
the
next
scheme.
stage, my lord, we'll get our answer also. My answer is definitely, my lord, because what is there in the mode of selection,
Yes.
I will say yes.
Yes.
That can be, my lord. Kindly see. So now, my lord, what happened at the first stage, before the examination was, I'm just repeating, my lord, I'm sorry. Before the examination, on receipt of the application.
Yes, we have understood your submission.
Obliged, much more. So now the next stage is after segregation of first preference candidates. Now 8.2 online computer-based test. This is central test. An online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement to be published before the recruitment. So there will be a central selection for all the candidates. Unlike OPSC, unlike EPSC, all the selection will be made in one place. So selection was made. So next, after the selection is over, my lord, first is the list, thereafter master list, thereafter the examination. The examination thereafter 8.3. Now our bone of contention is 8.3, my lord. District-wise and categorized draft merit list. Now I will read it along with 8.1. 8.1, my lord, already there is a first preference district list with them. So now the examination is over. Now the marks are to fitted into the first preference marks. So now, my lord, what is the procedure? District-wise and categorized draft list, merit list, will be published in OSEPA website. Full stop. Draft merit list will be prepared. Now probably this is the answer. Draft merit list will be prepared, taking into the consideration all district preference submitted by the individual candidate in order of preference, followed by merit rank. That is, for a particular district, after exhausting all candidates having first preferences, subsequent preference will be considered. In case of a tie, so and so. Now, my lord, we'll stop it here first, my lord. What does it say, my lord? As my understanding, subject to my lord's approval, the OSEPA website, after getting the marks, put it to the list prepared on master list under 8.1. Because after 8.1, my lord, now they have a list. Suppose only 30%.
Yes, sir.
So marks will be fitted to them. And thereafter, there will be a descending order of mark because the person who has secured higher mark will be number 1. So likewise, my lord, it will be descended. So accordingly, they have said preference will be followed with the merit. It doesn't say merit will follow with the preference. Had it been so, my lord, I have no case. So now you have the list, you have the marks, put into that in accordance to their marks and get the final list. Then what to do is, for a particular district, thereafter the first important is, after exhausting all candidates having first preference, subsequent preference will be given. At the first instance, though I have applied for 30 districts, if all the candidates, as per the vacancy position in different 30 districts, are exhausted, then there is no question of second, third, or 30th preference. If 30% applied for
Other district merit candidates cannot also
come to this manner.
travel into this.
Other districts. If they have opted for, if that is my lord final, as per the scheme of mode of selection, if I am directed to submit a preference and on my own volition I have preferred Cuttack, but I have secured good mark or bad mark, then Kalhandi. Even if less percentage mark, person securing less mark than me has been now observed in Kalhandi, I could not march into that place because I have not preferred it. That is the scheme. And it is none of the parties' case. Nobody is challenging this procedure. Nobody is questioning this. Neither now those are saying that we have secured very good marks. They are not questioning that. Had it been a case that yes, this rule 8.3 has been challenged, merit is to prefer over the preferences. The case, what is argued before minority is understood. But here is a case, the procedure is codified and it is done by the government. So now the state cannot come and say that no, it is wrong. A merit is to prefer over. So that is why, my lord, it is said after exhausting. So now, first of all, this 8.3 has to prepare as per the list. And the tie and all these things, my lord, that is there. So if they are getting it list, at this juncture, my lord, thereafter, my lord, 8.4. The next is, after this exhaustion and all these things, after publication of the draft merit list, all candidates in the said list will be called for verification of original documents at their respective district headquarters. Necessarily means, pilot, again, I will go to clause 8.1 and 8.3. The list is of the first preference, and now you will be called to your first preference district, and your records of certificates will be verified in that particular district. So therefore, a draft list as per the first preference district has to be published. But what they have done at this juncture, the verification of documents were fixed to 20th and 21st of December. At that juncture, we came because there was a draft list. What they have done, my lord, that is a mistake. At this juncture, after 8.3 and 8.4, at that juncture, we came. A draft list was published in Annexure 6 series, the writ petition. That is how they have done it, my lord. They have not given it. Again, it is in my writ petition, if my lord will see. As per the mark, the OSEPA has allotted the districts, not as per the preference. If my lord will see Annexure 6 for a moment, which is impugned before this, because what I have challenged in the writ petition. Kindly see, my lord, my prayer, page 106. At this juncture, my lord, what was my prayer in the writ petition?
Yes.
My lord, page 104, sorry, my lord, page 104. My
On the writ petition,
writ appeal, my lord.
writ appeal.
Writ petition, my lord, it is with page
You have
14.
annexed, huh?
If my lord holding my writ petition, page 14.
No, come to
Writ appeal.
writ appeal.
My lord, 104. the prayer in the writ petition. My lord.
Yes.
Under the above circumstances, it is therefore humbly prayed that this honorable court be graciously pleased to quash the procedure adopted by the OP number 2 for selection of junior teacher schematic and also the draft result sheet under Annexure 6 series, and direct the opposite part number 2 proceed with the selection strictly in accordance with the government guideline in resolution dated 22/8/23 under Annexure 1, and to engage the petitioner in their preferred districts with all consequential and financial benefit within a stipulated time, so and so, so and so, so and so. Because there was a wrong draft list, not adhering to either.
So you did not challenge the draft list.
Pardon, madam?
You did not challenge the draft list.
No, I have challenged, madam. Annexure
That
6
is
series
not
the
in
draft
your
list.
prayer.
Prayer I have read now, madam.
Please to
And-
quash. No, you want quashing of the procedure.
No, draft select list. Shall I read 1 second, madam? Was the procedure adopted by the OP number 3
And also the draft.
and also the
all-
draft list, Annexure 6.
All right.
So because our cause of action only came from looking into the draft literature which are published. Instead of the first preference listed, what they have done, they have allotted. They have given a go by to that particular preference we have given, asked by them to give. They have preferred as per their mark or whatever the condition, I don't know. They have said, though I have preferred, suppose Nabarangpur, I have been directed to appear in Bolangi or Palandi or some other district as per my mark. But that was not the purpose of this procedure or the advertising. If the procedure, my responsible submission, my lord knows, because I should not dare to say, but that famous Nazir Ahmad case, my lord, if thing is to be done in a particular manner, it has to be done.
Mr. Counsel, the problem is
My lord, sorry,
that
if I have committed wrong.
if we accept your submission
My lord,
and read those provisions like you are suggesting, you may be correct also, then the process itself will have to be held to be ultra vires Article 14 and 16.
my lord, no, but that my responsible submission at this stage is nobody is questioning that.
Even if no one.
My lord, yes, that is there, my
High Court.
that is there, because now we are in a appeal against the order of the honorable single judge. Before the honorable single judge or any other writ petition, nobody was questioning the procedure adopted by the state.
Even if no one questions.
Yes, my lord can have it. My lord, I'm not questioning, but now I am in the given case, man. I'm in a given case, I'm submitting. So my lord can do whatever, but whatever the facts here, whatever the procedure they have adopted, my
Right.
responsible submission is once the state has formulated a principle of selection, they cannot deviate from that and go for a separate selection. It was open for them to go for a selection according to the merit only. If there could have been, yes, or will hold a central selection and the merit will put to XYZ district, because there is no bar for them to send me. If I don't want to join in Kolhandi, veterans there, I have no choice. But once they have given me a choice, yes, you say in which district you will prefer. And I have given the preference number 1 is Kalhandi. Now this, as per their procedure, selection has to be confined to the Kalhandi only. That is my submission. And that is why the honorable single judge has also proceeded. So now, my lord, with this prayer in the annexure 6 to that list was the list they have prepared. They have given a heading, preferred allotted candidates. If my lord will permit me, I'll take annexure 6 is not there in the writ petition, it is there. Page 62. That was published in the website. I have downloaded and filed it. So it is a voluminous one, my lord. Selected pages are filed. Extract. Page 62 in the writ petition, WPC 978. If my lord, it will convenient, my lord, I've got the copies.
Yes. What is there?
This is that writ petition copy, if my lord wants.
What is there?
Yes, this is there, my lord. This annexure 6 is there. That they have not filed for convenience. I am giving it to my lord for. Only one page, my lord. Annexure. This is annexure 6, my lord. Kindly see, this is draft result sheet of junior teacher. This they have prepared. That is page 3. Well, first serial number, application number, roll number, category 1, 2. This I have given 2. Art, science, language. Now, district allotted. They have given. It is not preference district. They have allotted it. Ganjam, Korapur, Jaspur. As per that, probably this is on mark because marks are not been published, so I cannot say. But probably this is on mark. They have allotted the candidates, irrespective of the preference, whatever it is given. But this is the violation of rule. The procedure clause 8(3). That I want to submit. This was the objection before the Honorable Single Judge. At that juncture, my lord, the Honorable Court, when they were processing for the verification of document, because after rule 8(3), para 8(3), the next stage is the verification under rule para 8(4). So 8(4) notification they have given. They have fixed a date. At that juncture, when we found that yes, this is a wrong list and this is not in consonance with rule para 8(3), so we came to this Honorable Court. And this Honorable Court, the Honorable Single Judge, has passed an interim order in presence of the Learned Advocate General that yes, you may proceed. That 19/124 the interim order passed because it was on 20th. They said yes, you can go for verification. That will no final date. That was the order interim order. And thereafter, affidavit, everything was filed and finally matter was disposed of. The Honorable Court has taken note of this particular aspect. The Honorable Court has also gone to the selection and the procedure they have adopted in the pages 8.1, 8.2, 8.3, and 8.3. Honorable Court accepted our submission, what I am submitting, that yes, there is a deviation of 8.3. It is not a list of preference. It is a list on merit, maybe merit because merit was not published at the time, but it is not as per our preference. In course of hearing, we have also filed document to show, because in one end, the Honorable Court has said that no further proceeding, but they have produced, the state has produced, segregated the names from this annexure 6 and placed it to the court in a sealed cover that this is our district-wise list. Only to cover up their own mistake, I would say, my lord. To 8.3, they say, as per 8.3, we have prepared a list district-wise, so this is the list. That was not. But in certain district, how could you get our point? Because this is in sealed cover. But in certain district like Kalahandi, Sambalpur, Balasore, Gajpati, they have published it. What was in the sealed cover before this Honorable Court, but they have published it on their own, I don't know, in the website. So we immediately got it uploaded and found that the person so named in that list also have not referred to that particular district. We have filed the document along with the regender. I filed the documents at Annexure C by series. There to demonstrate the fact that the persons in the Annexure 6, the impugn order, you have allotted, they have not referred to this particular district. One district example, I can also right now I'll show from the record. That less number of posts advertised is the Gajpati. Only 4 seats in category 1, 6 seats in category 2. I have demonstrated also, I have filed it to the court, it is on record. None of the candidates who have applied for Gajpati, they have 87 candidates have applied for Gajpati. But none of the candidates have been selected against those vacant posts. Outsiders have come. Those have not preferred. Outside in the sense, those have not given first preference seat to the post to the Gajpati. They have been so selected against that.
Suppose there are 2 districts.
Yes.
In the state, for which no first preference is given by anyone. Then what will happen?
Well, I think this, yes, that will be a point. But here in this case,
forget. We are
example.
We are considering the procedure. We
Yes.
are considering the decision. We are
Yes.
considering.
Then, then it takes care of. Clause 8(3) takes care of that.
What?
It says, after exhausting all candidates having first preferences, subsequent preferences will be considered. It has takes care of, not that there is a vacuum. Suppose for Gajpati there are only 4 posts. People may think that no, I will not prefer it because I have less chance to succeed. So where there are large number of vacancies, I will apply for. But since all the candidates are directed to give 30 preferences, there is no case, as my lord have suggested, there is no case that one district will go with unrepresented. No. Because every candidate has to give 30 preference. Maybe all the candidates have 30 preference Gajpati.
No, are they compelled to give 30%?
Yes, madam. That is the format, madam. I have given the application form in that advertisement. Kindly see. They are compelled. That is kindly see page 40. That in that writ petition, I have given the application 4 application form I have given. That is the printed, that is the requirement. That is no dispute over that. knowledge that application will be rejected, man. Kindly see. Sorry. One of such application, page 40 of the writ petition I have handed over to man. It says, my lord, as my lord, Senior Minister Advocate General has also shown it to from my application. This is a printed application form. This is issued by the OSEPA, and we have to fill. Every candidate has to give it.
No, no, how do you say?
Pardon me?
How do you say that every candidate has to give 30%?
That is the prescribed form. That is the online application form, and I have printed. Get the everybody has bound to give. That is the requirement.
Where is the requirement that those are mandatory? Those. Is there anything?
That is mandatory under the.
It can be mandatory.
Yes,
but let us understand.
That is mandatory. Well, that is not.
The form is only,
I just because that is not the question put. That is there, man.
the form only says district preference for joining,
I will come to that.
district preference for joining.
Mine. I will answer to this after verifying because I
This, again, this district preference is not for selection. This is district preference for joining.
yes, man. Yes.
So if you
Because
go
this is
by
a district
this-
cadre post. This is a case, admittedly, this is a district cadre post. And we have to prefer accordingly, 30 districts. So first, that you give your first preference. And when they will allot me.
All right, but how do you say that all the 30 they were to be filled up?
So there is no asterisk to say that it is mandatory field to be supplied.
No, my lord, it is mandatory. Because immediately I cannot, I have to take a stop because this part was not there. If after launch also I can answer it because my clients are there.
No,
But
normally
that's
online
simply
application forms,
that
they put asterisk or red mark saying that they are mandatory field to be supplied or filled up.
yes, ma'am. But I'll just come after lunch. I will clarify this aspect of the matter, my lord. I am just holding it.
So I will continue, you will continue up to lunch.
You know, if my lord, but this particular point, my lord, not that way. Well. I don't want that, but because this is a question, immediately I
Okay,
know.
no, we are not in hurry.
No, my lord.
Yes.
I should satisfy my lord.
Yes.
Because immediately I have to read it. I will not waste my lord's time here. I will launch in the immediate.
Even
launch-
substance is
It is
irrespective of merit, wherever your
now
position.
my response submission is it is not the case that only merit is the criteria. Then many meritorious candidates are also there who have not applied. So now the selection is between the candidates those have applied for, and the process has been codified to all the candidates. So since the examination is there, this is a centrally selection because for each district, earlier they are holding the selection per district, but there was some allegation in some districts, some manipulation and other thing. So now they are holding the examination centrally, but therefore they have put 8-1 first, thereafter 8-2. 8-1 says you should segregate the application from district wise. Is the first preference. That is why I am giving emphasis on that. Once you have segregated the application form, now you get the marks on the selection. Whoever he has applied the first preference district, the marks will be fitted into that selection, and the selection will be district wise. So that is the purpose, because this is a district cadre post. So therefore, my response submission, merely because there is a selection test, whoever he is there in the sequence the highest mark, he will get an appointment. That is not there. Had it been so, my lord, para 8-3 should not have been incorporated to the selection. So once they have knowingly entered a provision into the procedure, so now the state cannot go back and say, no, I will not adhere to that. That is not permissible, my dispute submission is. And moreover, the judgments, as laid down by my lords, is if a thing is to be done in a particular manner, it has to be done in that way. And the private opposite parties now those are coming that we have secured a higher mark, so we have to get appointment, not this person. So that is also not a case, because they could have, because this resolution was open for them to challenge. They choose not to challenge. Now they cannot question that. That is my humble submission there. Since 8-3 is a particular provision in the list, and that is also a stage after 8-1, 8-2, and 8-3 comes. So it has to be filled up as per the procedure laid down there. That is my humble submission, which has been accepted by my lord single judge in this case. And so far, this today, my lord, see what happened, my lord. What the honorable court has said, Honorable single judge has not entered into the, said that I should be given appointment or they should be denied appointment. I also conceived to it. I was also having some homework. I found all these candidates securing higher mark will not be eliminated. Definitely they will not eliminate. Maybe it is a position. Suppose he has secured, by chance he has secured good marks. Because this is a computer-based test. Per chance he scored well. He has preferred.
By chance they scored well.
Because these are these multiple choice questions. I have answered. Well, so we have also sometimes we are sitting in that examination. So well, whatever it may be, I'm not going to that.
Objection to this.
No, well, I withdraw that.
No. When did he last sit for this examination? I want to know.
No.
Because when 100 says I am sitting for the exams.
No. When I was
Our children are now sitting for those exams.
30, 40 years. My lord. So now the question is, my lord, these points, the marks, whatever they see, they will not be eliminated as I have my homework proves. What will happen, my lord? If government has now allotted him to Cuttack, he may get an appointment in Balangir, because of his past preference. But he will not be eliminated. Let them demonstrate, nobody. Because today my senior has filed. I am obliged to him. I have filed it in Annexure C3 before the Honorable Single Judge, the discrepancy in the list. A person has applied for Gajapati, he has not been selected for Gajapati. All other persons, other than the person applied for Gajapati, only 10 posts, 87 candidates applied for, but 10 outsiders have come. The first preference, outside in this sense, those have not before first. Now today, my senior has filed with a memo these 2 documents. He has did that work for me, I think. For today he has given the first list they have prepared. 21% for Nabarangpur district, and out of 21, serial number 10, 18, and 20 are the outsider, not first preference. They are from their first preference was Moyubhan, Keunjhar, and Moyubhan. 3% out of 21. So 21 candidates got the selection there. So they have given a revised list. As per my argument and as per the judgment of the single judge, they have prepared the list. They say 21 by taking the first preference in Nabarangpur. Almost there is the variation is very nominal. So not that all are eliminated. And I got my challenge is, my lord, though I have applied for both, now as fairly submitted by my senior Mr. Advocate General, my lord. Initially, when they have issued the category 2 list, that page 3 of that that memo today my senior has filed. They have stated in the category 2, my lord, out of 18 candidates, they have written the first, what they have done, there are almost all are outsiders. On except one, this is for Malkangiri. Only 2% from, only one from Malkangiri. Serial number 1 is from Malkangiri. His past preference is Malkangiri, he got at serial number 1 because he has scored very high mark, 179 point something. Others were outsiders, other district participants. No, after revision, the last cutoff was 171.5. Now they have revised it after post judgment. So they come to conclusion, if all the first preference of Malkan district comes, my lord, again another 18 candidates will come. This first person who has applied for him continues to be at number 1, serial number 1, and others. And I came into the picture. My name found place at this Bhuiya. He came into the selection because I have preferred Malkangiri as my second preference. As per my mark, I come into the selection along with others. So this is for the, so my responsibility, if they would file a further document, all other persons from Bhadra, Keunjhar come into the Malkangiri, they might have been adjusted in some other district or in their respective first preference district. So my submission and the finding of the Honorable Single Judge is also that. Honorable Single Judge has not scrubbed everything. What does it say? The Honorable Court has said, you proceed with.
Sir, the only adverse effect of the result would be that there may be circumstances
Yes.
where a candidate scoring 165 will not get any place, whereas a person who has secured 140, he will get some position somewhere.
But maybe the position like that because of the stipulation in the selection. That is the process because of the selection procedure adopted by the government. And that is why I have read the first, I start with my argument, taking note of that Shiksha Sahak advertisement. The same situation, government would have rectified from that. knowing fully well there is a setback in the first writ petition by Honorable Single Judge, which has not been challenged with regard to Shiksha Sahaya. Same parameter provision. So if the government has thought of the same thing, they could not repeat it here. So
the decision of learned single judge will not bind court.
I cannot say so. Why shall I say?
You will have to say.
Yes. But my response submission is, in a given fact, whatever the challenge before the Honorable Single Judge, there is no illegality or infirmity in the order of the Honorable Single Judge. That much I can say, because the fact before the Honorable Court was that yes, the select list has to be prepared as per clause 8.3 strictly. Since there is a deviation and no cogent reply was given to this Honorable Court by the Honorable Single Judge, the Single Judge has proceeded as per the procedure and come to the conclusion. Now, only one more. That the argument has been advanced with regard to non-joinder of party. As my lord, the other day also, while my senior Minister Advocate General or my senior Mr. Rautrai was placing that paragraph, my lord have confronted them with the particular finding of the Honorable Single Judge. Has taken note of whether they are necessary. Only two more. I have given the judgments there also. Only two more judgments I want to give, my lord. For this simple reason, my lord, my dispute submission is, even if they are not made parties, let us assume they are the necessary party. They are not necessary party because it was a draft list. And draft list never gives any right. A list only give a right only at the stage of clause 8.6. Kindly have a glance to clause 8.6. That is the next stage. Thereafter, I will come to this judgment. Sorry, clause 8.5. Clause 8.5 only can give if you will go to the scheme. Page 79. Kindly see. After that document verification 8.4, the next stage is preparation of district-wise provisional merit list and approval. That is, there is a stage. Cause of action for them, at best, they can say that we are the affected party, accrued right, only there. Kindly see. Provisional merit list. After verification, somebody may be discarded because some wrong certificate, wrong facts, he may be eliminated. So now 8.5. Provisional merit list will be prepared after document verification of the candidate placed in the draft merit list. Then objection will be invited from the candidates who are placed in the provisional merit list and rejection list. There will be two lists at that stage. One is the select list, one is the rejection list. If suppose I am rejected, so reason will be given to me. So I will have a right to object to that list. No, why you have done it? Why somebody X name has been entered? That is the stage matter. But I came at the clause 8.3. And this says the provisional merit list will be approved by the competent authority at respective district after verification. This list is to be done as per the district list because the district is the cadre matter. The district cadre authority will have an approval to that list, inviting objection from candidate within specified time period as mentioned in the calendar of activities.
Inviting objections from?
Pardon, madam?
Inviting objections from
the candidates. Reject.
Candidates selected or even not selected?
Two lists will be there, selected and rejected. And at that juncture, objection is sought. Definitely objection, those have rejected, they will
so according to you, you could have objected also.
No, I could not. After verification. So only the selected candidates. This is probably I'm not clear.
No, let us see the resolution first.
Page 79. Page 79.
He says that only those who are selected would have. Where is that?
My lord, clause 8.4, number 8.5. 79, my lord. That resolution I was reading 8.3, my lord. Thereafter 8.4 is
document verification.
Document verification. After document verification, that is the stage. Preparation of district-wise provisional merit list and approval. That is the heading, my lord. My lord, what is? Provisional merit list will be prepared after document verification of the candidate placed in the draft merit list. Then objection will be invited from the candidate who are placed in the provisional list.
Oh, so this is not this
This stage has not
Objection,
come.
no, this objection was to be made only by the candidates who were placed either in the provisional merit list and
Draft
the
list.
rejection
In the
list,
draft
not
list.
otherwise.
Draft list.
All right.
That
We
is
have not
only-
reached there. Our name is not there.
That is only persons whose name found place in the draft
Yes.
list.
Yeah. My name is not there in the
So-
draft list.
So you could not have.
Verification was undertaken. In the verification, if somebody is disqualified, then he will be put under rejection.
Rejection.
If he is qualified, then he will be put under merit list.
Smile.
So that is the.
That
two.
is stage. So, but I have come to this honorable court at the draft merit list, 8.3 man. I came 8.3 and 8.4 in between. I came. This draft list doesn't bear our name. We came to the honorable court because that is in violation of 8.3. That is my sum and substance of my,
Right.
my lord. So therefore, my lord, the necessary parties, they are saying, now this list under 8.3, suppose somebody's name is there, he didn't get any right. A verification is there. Further, thereafter only a list will be published. There you will have a right. Some right will come. So then, now I want to place a judgment. My lord, even if my respected submission, here the procedure I am telling you, the procedure they have adopted is a faulty procedure. It is in violation of their own procedure. That is stage I have come to this honorable court. I am not challenging anybody's. My inclusion is not there. I have come, it's almost a draft list. It's not fine. Thereafter verification, other things are there at that stage. So at that stage, my lord, these persons, those names found place, there is no name, roll numbers found place in that draft list, have not accrued any right. My respected submission is that. Even if considering for a moment, there is a right, at best they can be proper parties. They are not the necessary party. This is the second. The third, my lord, even if let us they are the proper parties, what best argument they could have advanced at that stage? Because even if now, because normal course, my lord,
More than what could have been advanced by the state itself.
much of that.
This is what you are submitting.
Yes, ma'am. What they and whatever now argument, they are also arguing in the same line. So now the issue boils down to one point, whether this preparation of draft list is in accordance with Rule 8.3, sorry, Para 8.3 or not. The Honorable Single Judge has come to a conclusion, it is not. So therefore, the Honorable Single Judge has directed, you start from that stage. The Honorable Court has not scrapped anything. He says you start that in that stage. Prepare the list, everybody will. There is no problem. It will be in accordance with your own guidelines. So once you have framed a guideline, you proceed according to that guideline. So no prejudice to any other persons. Because there is no challenge to that clause 8.3. The judgments I am relying upon, my lord, with that, because when the this non-gender party is not fatter, they are not to be given opportunity of being heard. That is AR 1974 Supreme Court, page 1755. Other one I will to rely upon, but that Para 20 I rely upon.
Yes, when the policy itself is under challenge.
The other one is, my lord, there is a futile writ. The 2015 volume 8 SCC 519.
Futile, right?
Futile writ, yes, ma'am.
Means?
Yes. This useless formalities and other things.
No. Difference between.
Relying upon that judgment of Honorable Supreme Court of RC Tobacco, means that has been referred to there. I'm just giving 2 copies of that judgment.
They could not have used this expression, futile writ.
Matter?
Futile writ expression could not have been there.
No, my lord, that says that useless formality. So
Useless
formality. Useless formality. By relying upon the another 2005 Supreme Court 4233, that is referred to there. I'm just giving the copies. One paragraph is also quoted there.
Yes. 2005.
2005 Supreme Court 4203. That has been referred to by my lord in 2015.
Yes.
My. So my response submission is to sum up my argument, my lord.
Yes.
Since the government has issued a guideline, they have to strictly follow the guideline, and the entire process has to proceed in accordance with the same guideline. since there is a deviation, and I have demonstrated through records to the Honorable Court that yes, there is a deviation, it has not been followed, and therefore, and the Honorable Court has taken note of each of the statement. The Honorable Single Judge is, my lord, is a very exhaustive one, I would say, my lord, and it has taken all the points raised by parties and reached all the points. Therefore, this needs no difference of the. My lord, I am obliged to my friend, my lord, what question my lord have put to me, that application form, he has downloaded, my friend, it is. That is compulsory. That is compulsory. It is there, man. Rates, you have to bound to give 30%. Your application will be rejected.
All.
সমস্ত 30টা দেওয়া পড়বে।
Will you make a printout?
I will get a printout and I'll kindly.
No, not required.
So that is.
They will take note of.
Obliged.
Anything?
One line in that on behalf of. Well, the judgment which was cited by Justice Sharagi, that single judgment, my learned friend has cited. In fact, that is on the basis of a resolution which has been superseded by the subsequent resolution. Let's be kindly look to that. And that was a judgment where the matter was remitted back. If you also will see that that has been remitted back. And that judgment has nothing to do with the present facts and circumstances. And so far, our entire case is 8-2, and the notice has been issued under 8-2, and 8-2 has not been dealt with by the Honorable Single. On the merit, also already said, I have nothing to add. And so far, the judgment which was cited, that is a case where the policy was challenged. Here, the policy has not been challenged. Here, he has challenged the draft merit list.
No, his submission is that nothing more could have been argued by the private persons than what
But
had already been argued by the state.
Had we been implicated as parties, we could have at least bring to the notice of the Honorable Court that we have the meritorious candidate, we have exercised our right of preference, and we have been selected in terms of 8-2, and 8-2 could have been taken into consideration by the Honorable Single Judge.
The doctrine of, the theory of unfair trial with a fair appeal. 86 Supreme Court, Institute of Chartered Accountants. Honorable Supreme Court says that in case of this category, if you are not hearing a necessary party and subsequently pleading party in the appellate stage or hearing them, that would amount to an unfair trial with a fair appeal. The clear answer to that is 86 Supreme Court, and I give that.
And the Priyamada Das case judgment that division bench you also referred to, there is a case of they are qualified in the written test and a provisional list was prepared for the purpose of IOS test. That was the subject matter of challenge. Relying on the Kulwant Singh judgment, Para 25 will also be looked to that. The coordinate bench have clearly said that they have a right, whatever right, semblance of right, that they must defend it. They have a right to protect it. Therefore, they are necessary. Right to be heard. One thing.
Can I just put a request? Just a small request. One, another matter with regard to virus is posted today 2 p.m. But this matter has taken our night candle. Yesterday, we all were completely over this matter.
State is other side, of course.
Okay.
And that's why keep it to some other.
It may be difficult for you to get another date.
Light up popular.
Okay.
Yeah.
So I was just requesting my lord that item 56.
56, you wanted adjournment.
53.
53.
Request a further study. That is what
In fact, in view of that Senapati's case, but it is difficult to, we will have to make further endeavor to get over that.
Anup Senapati.
In that case, the repeal provision was not challenged. On the basis of the repeal, the judgment has been delivered. Now, your lordship was in that question that suppose that repeal provisions now you are challenging, suppose we will repeal it, that judgment will be redundant. That judgment will have no effect.
Yes.
Whether we can.
Really,
Actually, put that question, certainly we have to
That's a
answer.
very valid point, my lord. We'll have to answer.
Answer. Apart from that, other questions.
that will be unsettling decision rendered by Supreme Court.
That we'll address you.
We try to get it over, but
Yes. 53, when do you,
Next week, a particular date you also fix so that it will be.
next week, huh? Next week. Next week.
That will.
Mr. Naik has hurry to dispose of his matter.
Yes, we got Mr. Naik.
I think Mr. Naik should agree with us. Otherwise, there will be inconsistent pleas.
My husband said that he had challenged the virus of 2004 as well as 2009. So in any case, your worship will have to adjudicate 2004.
We'll hear it.
2009 is a consequence, sir.
In 2009, I think there is no repeal and saving.
No. 2009 repeals 2004.
No, 2008. Another.
2009, there is no repeal and saving.
That is that.
7th May.
All right. 7th. Obliged.
I'll join the question.
Item 9. I have sought for the sanction order, work order under RTA Act, my lord. I could not get it. I seek 2 weeks more time to get it, my lord.
TI Act, why do you, why?
My lord, that the cremation ground of our village, 3 villages, the sanction, the amount has been sanctioned for thrashing floor, my lord. That cannot be done. Therefore, that order your lordship has sought for, my lord. Therefore, I have applied for it, my lord. That government can construct the thrashing floor for another village on our cremation ground, my lord. Therefore, that disturbance has been created. They have their village, they have their own cremation ground, my lord. Separate cremation. It is the cremation ground of 3 hamlet villages of village Padanpur, my lord. Since there are a number of tombs, some tombs have been demolished, my lord. Now 144 has been imposed by the administration, my lord, at present.
My lord, according to the affidavit filed by the petitioner, I think there is some settlement, and that
No,
is that
no
annexure
settlement
6,
has been, 144 has been imposed. my lord.
Annexure 6 to the affidavit, additional affidavit.
Yes.
There is some settlement by the local tahsildar in presence of both the parties.
That's-
And that is your document.
My document, I have not given that out.
There is, it is in vernacular
That is
language,
vernacular language.
but
they
there is
have-
some settlement.
No,
And it is directed that this user will be
No, what do
status.
you want us to decide?
Decided government cannot construct a thrashing floor on the cremation ground of our village for another village, my lord. That we are challenging, my lord.
Government cannot construct.
A thrashing floor, my lord, for paddy thrashing, my lord.
What is that?
Thrashing floor means, my lord, the paddies are harvested in a floor, my lord, after cutting the paddy from the field, my lord. That is called a thrashing floor, my lord. That 3 Mauja Padanpur under Dampada block, my lord, Tahsil, there are a number of hamlet villages, my lord. Each hamlet villages have their own cremation ground since they are both fathers, my lord. With the 3 hamlet villages, we have a cremation ground, my lord. Now another hamlet village, that is Totapoda, for the cultivators, the government has sanctioned money for construction of a thrashing floor in our cremation ground, on our cremation ground, my lord, which we are challenging. Now the administration has imposed the 144 my lord there. For the
Also, can that be decided in?
Report one my lord, one case I have brought my lord. Therefore, I want to order. One case has recently decided by this honor court that government tried to construct a OSRTC bus stand, Orissa State Road Transport Corporation bus stand, on the cremation ground of a village. My lord. This honor court held that if you want to construct the bus stand on that cremation ground, you have to provide the space nearby place for cremation ground, my lord. That you can't construct anything on that land, therefore that the restriction was imposed by this honor court, my lord. Now, but if any private party is there, my lord, your lordship should not interfere in the writ petition, my lord. Now, the BDO has himself, BDO Dampoda has sanctioned money for construction thrashing floor. BDO has no jurisdiction to sanction money for construction thrashing
So
floor.
does he admit that it is a graveyard or something?
Thereby it has been recorded in the record
Huh?
of rights. Record of rights.
Record of rights, that is not there. We cannot hold on the basis of record of rights that the nature
No,
of.
they have admitted it, my lord, that the executive magistrate has imposed 144.
These matters should
I will
not come to
produce,
the-
my lord, that order. Your lordship grant me 2 weeks time, my lord. I
We should
produce.
not interfere in such matters.
My lord, your lordship kindly see this judgment of this honor court,
We
my lord.
will see, surely see.
The item.
This
number
is
three.
Sarvasadaran public
Mr.
land, my lord.
Mr.
Of our-
Mahanti, Mr.
But-
Mahanti,
Yes,
Annexure 6,
yes.
item number 3.
In the affidavit I have filed, my lord.
Item number 3, ଯେଉଁଠାରେ ଶବ ସତ୍କାର କରାଯାଉଥିଲା ସେଇଠାରେ ତାହା ବଳବତ୍ତର ରହିବ ଓ ତୋଟା ବାଡିର ପିଲାମାନେ ଯେପରି ଖେଳୁଥିଲେ ସେଇପରି ଖେଳିବେ।
Yes.
The status quo.
That is what
In
I
that
wanted
sense.
to bring it to your lordship.
That they admitted it is
No, this
yes,
is the
cremation
settlement.
ground.
That is the declaration of the
Tahsil.
That is
government.
Tahsildar. Tahsildar.
IIC,
BDO has
Tahsildar,
sanctioned.
BDO is also a signatory.
Talabasta outpost in charge officer was signatory.
BDO is also a signatory.
BDO,
Block
BDO
development.
Banki Dampada, Chairman Banki
Maki, all
Dampada
members.
block, and Tahsildar also.
Yes. I have given, my lord, that vernacular. I have a translated copy of that.
After this, no cause of action survives.
Still that is under process of
No, thereafter, my lord,
it is under process of settlement as it appears.
No,
Sthayi
144,
ସମାଧାନ ନ ହେବା
after
ପର୍ଯ୍ୟନ୍ତ-
this, my lord, 144 has been imposed on that.
ସ୍ଥାୟୀ ସମାଧାନ ନ ହେବା ପର୍ଯ୍ୟନ୍ତ ଉଭୟ ପକ୍ଷର ସର୍ବସମ୍ମତି କୌଣସି ଅପ୍ରୀତିକର ପରିସ୍ଥିତି ସୃଷ୍ଟି ନ କରିବା ପାଇଁ ନିଷ୍ପତ୍ତି ନିଆଗଲା। So that has not yet been settled.
No, it has not. 144 has been imposed, my
So
lord.
at this stage,
It's the sacred place of for our villages, my lord.
A
It is
committee
sacred
was
place, my lord.
constituted. A committee
Your
was,
lordship grant me, I will produce that sanction order.
so in view of this
Sanction order or
annexure
what?
6, no cause of action further
See,
survives.
Mr. Counsel, we have to be very careful
Yes, I know.
while exercising our power of judicial review, particularly in such matters.
But
Because these things may require evidence to be adduced. We
well,
don't
there,
know.
if my lord, any private litigations in between private persons are
Who
concerned,
knows?
my lord.
Who knows?
My lord, here there is no privacy. Admittedly, it is our cremation ground. Government,
Admittedly,
I
who
am
knows
challenging
that?
the action of government, not any other person.
Who has
Let them file a return, my lord. Let them file a return. I will produce, my lord,
What
that
is?
sanction order of the for thrashing floor and also the 144 order.
Is it mentioned in the sanction order that it is going to be constructed on a?
They can't. Government
Something
cannot
called-
do it on our own cremation ground. My lord. That has been decided in this.
Sir, you are making your submission as if everything is admitted.
No, my lord, I am not doing. I am gone. I have a limitation, my lord, for making submission.
These
I
things-
cannot cross my limitation
we-
at all. I will submit, my lord, within the four corners of law, my lord. If your lordship, when I am appearing and submitting, then your lordship kindly see this judgment.
Yes, published Annexure 6. The theme of the 6 points have been agreed to by
Annexure 6A or 6?
Additional affidavit dated 8th February. 8th
Acha.
February 2024. Additional affidavit.
Uh-huh.
Video and chairperson and OIC. So first point is, they have formed a committee for maintaining peace. And second point is, still final settlement is status quo. The children has never claim, they will be visited. And the cremation will go on as they were. And they will looking after the peace and tranquility in this place. Very final settlement. So till now, settlement has not yet been arrived at. So we are exploring.
Already
they are taking the
Status quo ante was directed to be maintained and a committee was constituted to look after this issue and they will settle it amicably. That is the purport of this Annexure 6. Purport, my lord, thereafter the dispute.
You file an English translation of this.
Yes, my lord, I filed. No, I have filed, my lord. The English translation I have already filed.
It is there.
That is there, my lord. Let me read, my lord, that.
It is
Second
very-
paragraph. That has been annexed, translated copy has been appended to that Annexure 6, my lord.
Translated copies.
Yes, yes. The dispute regarding the cremation ground of villages Totabadi, Godipatna, Gopandhan Nagar, and Padanpur are discussed for resolving the same. Do you also get me?
Let us see.
My lord, Annexure 6 translated copy. You will also get, or I am giving my copy, my lord, you will also kindly see it. Watch.
So already they are taking steps.
My lord, a permanent committee is constituted taking 10 members for each villages. It has been decided that till the dispute is permanently resolved, both the sides shall not create any disturbance. The cremation shall be done at the place.
This committee is already looking into.
No, thereafter, my lord, disturbance was created. 144 has been imposed by the administration, my lord. I have not produced that. I have sought for the certified copy of that order, my lord. Therefore, I am praying before your lordship that 2 weeks time may be granted. I will produce all the documents for your lordship.
What for? What?
My lord,
what
whether
shall we
my
decide?
lord, my sole contention, my lord, sole point, can government construct a thrashing floor on the cremation ground of the villages for another villagers, my lord?
Can a government construct a hospital on that ground or not?
My lord, that therefore, my lord, this is in the Honorable Supreme Court, my lord, that the Honorable Supreme Court in 2011, volume 11 SEC, in Jaspal Singh's case has given the findings regarding construction of the cremation ground. Basing on that, this Honorable Court, my
What is that, Jagmal Singh?
they say where the land is recorded samsan or burial ground, graveyard in the record of rights and same is absolutely required for the project. The requisition authority shall have to provide equal extent of suitable alternative sites having similar facilities as are available at the existing sites.
So they will not disobey the Supreme Court's order.
No, they are not. Therefore, this Honorable Court, my lord, in the case of the Prabodh Kumar Senapati, has directed the authority not to construct, my lord, that
So whether
oversight
construction
bus
has been done.
they are in
Therefore, the
another case.
committee has
But
been
here,
constituted.
my lord, we have our cremation ground
No,
cannot.
are we sub-divisional officers?
Pardon?
They are already, there is a committee constituted for that purpose.
But that
They are
has not,
looking into it.
that has not been resolved, my lord, till date.
That will not be, should be resolved. And there is a decision of Supreme Court, they will take into account.
You will also direct that committee
They-
shall
that they will do
resolve
it.
that. If
That
you will
they will
also,
do.
the committee shall resolve that issue.
Petitioner claims to be ward member of ward number 15, representing the villagers of Godipatna,
Rautratpur
petitioner
and
number 1. Comma, petitioner number 2 is ward member of ward number 16, representing villagers of Rautrepur, whereas petitioner number 3 is member of ward number 17, representing people of village Bhoi Sahi. Petitioners number 4 and 6 claim that they are representatives of the villagers of village Godi Patna. Similarly, petitioner number 7 is the ward member of ward number 22, and 22 petitioner number 8 is ward member of ward number 23, who represent the people of their wards. Petitioner number 9 is the husband of Panchayat Samiti member of Talbasta Gram Panchayat. Is this a post?
Pardon?
Is this a post? Husband of?
He's not holding the post.
Odd kind of description. They have approached this court by filing present writ application in the nature of public interest litigation, seeking a direction restraining the opposite parties from constructing a thrashing floor and a playground on plot number 322 of Khata number 530 of Mauja Padarpur, which has been recorded in the records of rights as Asmasan.
Yes,
Huh?
cremation grounds, Samsan.
Asmasan. Samsan. Stop. Next, Learned Counsel appearing on behalf of the petitioner has placed reliance on a Supreme Court's decision in case of, give us.
Yes, I have given my lord that.
Jagpal Singh versus State of Punjab reported in 2011 volume 11 SCC 396. Give us.
That I have not got my could not answer that. That observation is there, findings given below. It is recorded by this. The finding has been recorded, my lord, on that page 93 of that judgment.
He has
2011
Next.
11 SCC.
It, however, appears from the records that a permanent solution of the dispute relating to the said ground for being used as for construction of a thrashing floor and a playground, comma, a permanent solution of dispute.
However, from the records, that the permanent solution of the dispute relating to the state ground for construction of the thrashing floor and the playgrounds.
A committee has been constituted, headed by the subdivisional police officer Banki and other officials, including block development officer of including concerned block development officer of Banki Dampada. Stop. In a meeting held on 20/12/2023, the committee is said to have resolved as under. वो quote कर दोगे annexure 6 उसका. In our considered view, since the district officials are already looking into the dispute arising out of proposed construction of a thrashing floor and playground over the land in question, comma, we are not inclined to proceed any further in the present matter. First off, it goes without saying that the respondents shall keep in mind the law laid down by the Supreme Court in case of Jagpal Singh versus State of Punjab bracketed Supra while taking any final decision in this said regard. This application stands disposed of accordingly. Yes, privilege.
Yes, madam. Yes.
Could you get that? Jagpal Singh, could you get?
No, yes, I want to agree. Yes, the is 396.
No, he is referring to AI. We have SCC. 396.
96, madam.
No, there is something.
No, 396.
Oh.
Para 3J, my lord.
So you are relying on Jagpal Singh.
Jaspal Singh.
Jagpal Singh, in this case, writ petition was not filed.
Their suit was a pilot.
Suit was not filed. Some application under Section 7 of Punjab Village Common Lands Regulation Act to evict the appellants. So these are questions of facts. We should not.
They have admitted, my lord, actually, that the Prabhat Kumar Senapati, my lord, in which this judgment Jaspal Singh has relied upon, my lord, this is the writ petition has been filed.
All right.
So I pray your lordship, one line may add, if at all that law laid down in that case is applicable, then
This is what we have said.
yes, if at all the law laid down in that
Judgment
yes. My lord,
is applicable in the facts and circumstances.
yes,
That is
madam.
obvious.
Yes. Your lordship also quote that Prabhat Kumar Senapati's case also.
Useless. Not required.
But there, this honor court interfered, my lord.
You could have filed this. Why have you filed writ petition?
No, their writ petition has been filed.
Public interest litigation. That was not a public interest litigation.
No, it is not public. Their Prabhat Kumar Senapati is not a problem.
Not a public interest
No.
litigation.
Here because
See, we have to decide. In fact, something was laid down in case of by Supreme Court. That has to be followed in the background of the facts of that case. Suppose a suit is filed and finally it is decided by Supreme Court. So,
my lord, frankly, I am submitting before lordship, my lord. Last night I have gone through the number of judgments. All the judgments are arising out of the suits.
That is what we are saying.
This frankly, but
we are,
I got this only this the Prabhat Kumar Senapati's case. Which is the
we understand that. Therefore, we are observing that these are such areas where we should not record any finding. We should refrain from recording any finding. That will have, so if we record a finding and a suit is filed, The civil court will be bound by the finding recorded
Yes,
by us.
my lord. Why I
So that
filed,
is
my
right.
lord, why I filed, my lord, it has been admitted by the administration, district administration, this is a cremation ground, some sort. And the government himself, BDO, without, my lord, following the law, has sanctioned the money for construction. Therefore, we filed.
Whether the entries made in records of right decide the title.
No, my lord, in writ petition, the title cannot.
Not
be said.
everywhere. Whether one can claim title on the basis of the entries made in the records of rights.
No, my lord, that is, the RWA does neither create title nor extinguish the title. But it has been admitted. My lord.
Admitted?
Admitted that it is a cremation.
They will see.
Obliged, my lord.
Item number 10.
10, my lords, my place. My lord, it's identical to item 53, that ultra virus matter, my lords. It has been adjourned to 7.
Ultra virus of what? Ultra virus?
2004 GIA, my lords. Granting order.
Which one?
53. 53. It has been adjourned to 7th.
So let that matter be taken up at
My lords, along with that.
7th May. 7th May.
Obliged.
Matter will come after disposal of that matter. 4 weeks.
So.
That will become.
Item 11.
Please, Your Lordship. Your Lordship, herein we are challenging Regulation 13 of the Orissa Real Estate Development Authority Regulation, my lord, which has been brought in by a notification dated 26th August 2021, my lord, which is at your Lordship's page 17.
Annexure?
My lord, Annexure 2. And section 2 of the said. Now, the relevant portion is at page 18. The regulation 13, which we are challenging, is at page 18, my lord.
Yes.
My lord, it says, may I quote, it says all promoters have to file online application within 45 days from the date of approval of building or layout plan by the local authority. For late submission of application, the applicant has to pay late fee along with application at the following rates. So, my lord, A, B, C, D, E, F are all the rates for all the delays, my lord. If the promoter files online application after 75 days and before after 45 days and before 75 days, then the A prescribes a fee, my lord. Then similarly, B, C, D, E, F. Now, my lord, we are challenging this, my lord, on the ground that this is ultra virus of section 3 of the Act, the Central Act. Now, my lord, the Act itself does not prescribe, my lord, the Act itself, section 3, does not prescribe any time limit. Now, my lord, what section 3 of the RERA Act says, if your lordship has, my lord, section 3 of RERA Act.
Real estate, regulatory.
Lordship has section 3, madam, of the Central Act, my lord, which is RERA Act 2016, my lord. No, the entire is Real Estate Regulation and Development Act 2016.
Where? 53. You are
Well-
referring to section 3.
Yes, your lordship. If your lordship has that OLR book, my lord, 4-in-1, it might be page 53. Might be page 53, your lordship. My lord, may I state, my lord? Lordship, my lord, Chief Justice has it, my lord? Yes. My lord, it says prior registration of real estate project with Real Estate Regulatory Authority. No promoter shall advertise, market, book, sell or offer to sell.
Now, please read.
offer to sell, or invite persons to purchase in any manner any plot, apartment, or building as the case may be, in any real estate project or part of it in any planning area without registering the real estate project with real estate regulatory authority established under this act. Now, look, this is the basic purport of the act, that if you are intending to sell or market or book or advertise, then you need to register it under the authority. Now, my lord, may kindly see at the bottom, now, my lord, clause 3(2). 2 says, notwithstanding anything contained in subsection 1, no registration of real estate project shall be required. Now, my lord, for this purpose, C might be important. For the purpose of renovation or repair or redevelopment, which does not involve marketing, advertising, selling, or new allotment of any apartment, plot, or building as the case may be under the real estate project. So, my lord, it is my respectful submission, my lord, if your lordship is a conjoint reading of section 3(1) and 3(2)(c) will make it clear that the purport of this act is to say that, listen, if you are planning to market, sell, advertise, or offer to sell, then it is a prerequisite that you need to be registered under the authority. Now, my lord, it does not say, it does not link A to the getting the plan approval, my lord, the structural plan approval, number 1. Number 2, it does not say within how much time. Now, my lord, my humble submission is, while this regulation go ahead of section 3 and under regulation 13 puts this time frame, that is prejudicial for following reasons, my lord. Now, my lord, may kindly envisage a situation, my lord. A. Now, my lord, my lord knows that, in fact, section 3 also says anything beyond 8 apartments. My lord, may kindly see also section 3(2). It says anything beyond 8 apartments or 500 square meters. Now, my lord, if I am building something, let's say I'm building an apartment of 10 flats. Now, today, I don't need to sell, or I'm not trying to advertise. I have my money, my lord, I am building it. Now, my lord, I may build it. I may, if at all, after building it, completing it, I decide to sell, then I have to get registered at that point of time. That's point number 1. Now, my lord, point number...
So, what is the definition of promoter?
Yes, my lord. My lord, may kindly see the definition of promoter is at, my lord, 2(1) at 2L, my lord, at the same page, my lord. At page 51 of your lordship's book, my lord. May I read, my lord? 2(1) ZK says promoter. ZK. May I read out, my lord? A person who constructs or causes to be constructed an independent building or a building consisting of apartments, or converts an existing building or a part thereof into apartments for the purposes of selling all or some of the apartments to other persons and includes his assignees. Now, 2 says a person who develops land in...
Come to regulation 13.
Yes, your lordship. Yes, your lordship.
So, then you have to file online application for what?
My lord, for registering myself or the project under the authority, which is the RERA authority, Real Estate Regulatory Authority.
No, unless you are registered, 13 will have no application.
Absolutely, my lord. I completely bow down, my lord. Now, but what 13 says, my lord, is within 45 days of getting the project approval, which is the structural project, my lord, from BDA or CDA or wherever I am. Now, within 45 days, if I don't register it, then there is this penal.
This registration and that registration, those are 2 different things.
No, my lord, my humble
Your registration as a promoter is one thing.
My lord.
And this application, therefore, we want to know,
my lord,
that this online application is for what?
My lord, the same thing. May I read out section 3 again, my lord? 3(1).
Yes.
Says no promoter shall advertise, market, book, sell, or offer to sell, or invite persons to purchase in any manner any plot, apartment, or building as the case may be in any real estate project or part of it in any planning area without registering the real estate project, not the promoter, my lord, the project itself, with the real estate or regulatory authority established under this act. So, my lord, so what, now this is the act, my lord, what the regulation says, that listen, the requirement of under section 3, you have to register the project. You have to register within 45 days of getting the plan approved. If you do not do it...
Your sum and substance of your argument is you are raising a structure for yourself. Yeah, it is yet to be completed for you. You get some approval from development authorities.
Hello.
So from that date, from the approval date, you have to comply with this
Regulation 13.
regulation.
My lord. My lord, there can
So
be
that was redundant or unwarranted when you construct your own
I complete.
without intending to at that stage, without intending anything for advertisement or marketing or booking or these.
I bowed down, my lord. My lord, that is option. That is my situation number one. Situation number one is, let's say I'm building a 10 flat apartment, which under law I have to register if I want to sell. Now today, when I get the approval and I'm constructing it, I don't have an intent to sell. Now I might sell it after 1 year or 2 years. Then I have to, before getting allottees or getting money of the allottees, I have to get it registered. That option number one. Now, my lord, imagine a situation where I am as somebody who goes and gets a project approval. But for market conditions, my lord, let's say I've gotten into a place where now there's no response, my lord. I don't think that it will sell. So I might not construct it today. So then the requirement of going and registering myself in RERA within that time frame may not be required, my lord. This I'm saying, my lord, is added, which does not take into consideration these facts. Now, my lord, third option could be, now, my lord, may kindly see, I get a plan registered, my lord. Now, I get money from the banks. If I get money from the banks, my lord, to complete the project.
You are challenging statutory provision.
The regulation, my lord, yes.
The regulation.
Yes, my lord.
So you must show that this provision violates what?
That's what I'm saying, my lord. As your lordship saw section 3, section 3 says.
So if you don't file any application, then what will happen?
Yes, my lord. If I don't
you
file.
got an approval?
Yes.
You don't want the application of regulation 13?
Yes, your lordship.
So if you don't do, then what will happen?
Now, my lord, my humble submission is, if I do it at a later stage, if I want it at a later stage, these are the penal provisions.
If he doesn't, if he decides not to.
No, my lord, if I decide not to, then only RERA itself is not applicable. That will not be applicable, my lord. My submission is, now, my lord, when I'm planning to do it, I don't require to go and offer to sell. I'm not needing money from the individual allottees. So I'm completing it myself. Now, after completion, I decide to sell it at a future point. Then when I go to register myself, under regulation 13, they will say you did not come within 45 days of your building approval. So these penalty you have to pay.
It's urban development.
No, this is not urban development. My humble submission. No, urban development is a BDA or CDA which looks into how you do it. That is, my lord, that's a development authority.
If you keep a plot vacant,
my lord?
If you don't develop, despite having approval obtained,
my lord,
if you don't develop,
then, my lord, I am under the obligation of the development authority can take action. This is not about development authority, man. This is purely real estate regulatory authority, who under section 3 can only regulate if I am trying to sell or buy from a allottee. So this is, my lord, to protection of allottees. This is only for, that is what my intention was, my lord, of showing section 3 is RERA only concerns itself that if you are trying to sell, market, book or allot, not when you are trying to construct. Construct is the local development authority, as your lordship said, my lord. If I'm taking permission, if I'm not constructing, then CDA or BDA will take action, not RERA. My lord, there is an interplay between two authorities. One is
13 says all promoters.
All promoters, my lord.
And you come within the fold of promoter.
Yes, my lord. I am a body of promoters.
Who constructs or causes to be constructed.
Yes.
An independent building.
Yes.
Or a building consisting of apartments.
My lord.
Or converts an existing building or a part thereof.
Yes, my lord.
Into apartment.
Yes.
For the purpose of selling all or some of the apartments.
That is what I'm stressing on, my lord.
And includes his assignees.
That is what I'm insisting on. Again, even the example of promoter here is somebody who wants to sell. Now, I may not want to sell today. I might want to sell after 6 months or after 8 months. But my decision of doing it, why should I be penalized, which is not there in the act? That is my humble submission. I completely bowed.
It says advertise.
Yes, my lord. Even advertise? Absolutely, my lord. So, my lord, my humble submission is I completely bow down to section 3.
All right. So why are you challenging?
My lord, as I said, my lord, may kindly envisage three situations.
No, forget situations. See, you cannot challenge a statutory provision in abstract. There must be some reason.
My lord, my first reason is
First reason is that you are a promoter.
Yes, my lord.
And then?
My lord, under the Act, my lord, my first submission is Regulation 13 is not in consonance with Section 3. That's my first.
All right. How does it affect you?
Yes, my lord. My problem is, my lord, if I today get a building approval.
Have you got any approval?
My lord, this is a member. My lord, these are happening of members. So this is a group of promoters, my lord. So, my lord, what they have realized today, because, my lord, I also should fairly submit, my lord, this is a regulation of 2021. I must fairly submit, my lord. So, your lordship can also pose a question, my lord, why 2 years after?
But no.
In these 2 years, my lord, what we have
There
realized.
must be cause of action for you.
My lord, what has happened in these 2 years, my lord, is if there is a being delay, my lord, where there are other market conditions as well for which we are looking at it.
Forget the world. So come to your case. You are a promoter.
I'm
you
not a
must
promoter.
have got a plan approved.
My lord.
So where is your plan approved?
My lord, I am not a promoter. I am a body of promoters. That's why I say, my lord.
You are an association.
Association of promoters. Association. My lord, this is creating impediments for our members because, my lord, they are under a compulsion to register within 45 days. If they go beyond, there is a penal provision for our members, my lord. That is not only for our members, for everyone, but we are concerned about our members. Now, my lord, this Regulation 13 is not as per the Act. The Act does not say that, listen, irrespective of whether you're trying to sell or not sell, there is no connection to my building plan. That's my humble submission, my lord. Regulation 13 connects registration with the authority with building plan. Section 3 says nothing about building plan. It says that if you are planning to advertise, sell, and all that has to be, my lord, scrupulously followed. I'm not saying that at all. Section 3 has to be scrupulously followed. But I am not doing anything. I'm not even trying to advertise, market, book. I might be taking stocks. I might be looking at the market dynamics, my lord. I might have there is a situation where our person has taken a thing and they are not wanting to build now. Or not go to advertise.
For maybe for ulterior reasons, you are not building.
My lord, what
you have got your plan approved.
My lord. But I'm not going for any sale or advertise.
Yes.
My lord, assuming if there is any ulterior motive, then it is the building development authority, which is like Cuttack Development Authority, Bhubaneswar Development Authority, which is giving me the plan approval. They can take action, saying that, listen, you have taken building approval, but you are not constructing. As your lordship knows, my lord, a lot of them have it. Section, my lord?
Yes.
Yes, my lord, 4.1. Yes, my lord. Every promoter shall make an application to the authority for registration of the real estate project in such form, manner, within such time and accompanied by such fee as may be specified by the regulation made by the authority. Yes, your lordship.
To regulate that, the regulations have been framed.
Absolutely. My lord, may kindly see section 85, which empowers them. My lord, may kindly see section 85, which might be in page 95 of your lordship's book. It says the authority shall.
Yes, we have seen.
Shall, within a period of 3 months of its establishment by notification, make regulation consistent with this act.
Yes.
Now, my lord, my humble submission is section 3 and regulation 13 is is inconsistent. That's my humble submission. Regulation 13, which says that you have to do it within 45 days of getting a building approval, that is inconsistent with section 3, because section 3 does not say anything about your building plan approval. It says that, listen, if you have to sell, buy, advertise, any of those things, you will have to first get registered. And that has to be scrupulously followed. I'm saying you
So
cannot.
if you don't have to buy, sell, advertise, market, book, anything, then why are you concerned with the regulation 13?
My lord, one point is obviously if I don't sell it, I don't have to do it.
Don't do it.
No, my lord, it's the time frame. The regulation 13 says time frame. Within 45 days, you have to do.
Sorry.
My lord, I'm not, my lord, may kindly allow. My lord, section regulation 13 is not applicable to people who don't want to sell those things. It's obviously, my lord, if somebody does not.
My lord's query is, as yet you have not shown any prejudice caused to a particular promoter.
My lord, the point is this. Now, my lord, this 45
the
days.
Abstract you are saying with some examples or illustrations.
I completely.
In coming to conclusion that there is some inconsistency.
I completely bow down, my lord. My humble submission is this time frame which has been provided, it has no basis, my lord. My lord, may kindly see. They have said, well, if I'm sorry, my lord, I'm not able to satisfy your lordship. My lord, my humble submission is 13 says that building approval, if you have got today, irrespective of you want to buy, sell, do whatever, within 45 days, you get it registered. That's what, my lord, it says. Within 45 days, you have to get yourself registered. It does not say that if I am, my lord, I have no problem with regulation 13 says, within 45 days, if you want to buy, sell or do it. Now, if I want to do it 6 months after.
You want to say that you may get a building plan approved.
My lord.
All right.
Yes, my lord.
That is the job of the BDA.
Absolutely. Bow down.
And thereafter you decide that you will not construct the building for 10 years.
No, my lord, not construct. My humble submission, not construct.
All right. Not
I'll construct.
No, you will not advertise.
I'll not advertise. I may construct. No, my lord, may kindly.
Yes, you understand. You may construct, you may not.
Yes, my lord.
You may not construct.
But if I may not construct, my lord, may kindly. If I may not construct, then I will be penalized by the authorities.
Yes.
That's a building, CDA, my lord, BDA. Now, my lord, here it says, if I'm not constructing, they will take action because I've given you approval. Why aren't you constructing? There might be a condition there. Now, my lord, here is a point where they are saying that irrespective of that, you get registered under this authority, which is the RERA authority, which according to me under section 3, the liability of only getting ourselves registered is only when I'm trying to buy, sell or do it. Now, my lord, today, my lord, may kindly see, section 3 says beyond 8 apartments. Now, my lord, today.
No, give us one example where it has happened that a plan was approved.
My lord.
The fellow was not intending to construct, to advertise, to sell.
My lord.
And because of that, this regulation has prejudiced him.
So,
otherwise, you have just come to have a declaration from the court.
This seems premature.
Not only premature, it appears to be lacks bona fide, Mr. Counsel.
My lord, then I'll have to satisfy your lordship, because if your lordship says that it lacks bona fide,
yes,
your lordship might be complete. I completely bow down on the first option. No, my lord, I completely bow down on your lordship's first observation that your lordship may want a cause of action specifically if somebody is prejudiced. Now, my lord, to that effect, my lord, I completely bow down, my lord. My lord, it may not lack bona fide because, my lord, these are real issues which are being faced today, my lord.
So what is the online application? Let us see. What does this mean? This online application?
Well, before RERA, my lord, when you do get a project, you have to get yourself, my lord, if I may.
No. Where is that online application? There must be in the regulation. This is amendment.
My lord, this is the amendment. This regulation is there, my lord. My lord, in that book itself, the regulation is there, my lord.
$175.
193, my lord. Application for registration of real estate project. 195 is the form of registration if your lordship wants to know.
No, which is the regulation?
Yes, my lord. Under the regulation only, regulation 3, my lord. My lord, may kindly see regulation 3. 184. Application by promoter.
You are referring to?
My lord, Real Estate Regulatory Authority Regulation 2017. The Lordship has the same page, it might same book, it might be page 184.
Yes.
My lord, Regulation 3 says the application by promoter, every application for registration of a new or ongoing real estate project, and my lord, may kindly see it also says ongoing real estate project made under subsection 1 of section 4 by the promoter or a person authorized by the promoter shall be in form 1 and shall be in triplicate with requisite documents as mentioned in form 1, prescribed under the provision of subsection 2 of section 4, duly signed and authenticated at the office of the authority until the application procedure is made web-based for registration of real estate project. Now, my lord, that form is in 193. My lord, so it says ongoing real estate project as well. If it's an ongoing real estate project also, I can go and register. Now, if it's an ongoing real estate project, I go and register. Regulation 13 says you pay penalty. When, my lord?
No. If you can begin, because after having this approval of your building layout plan, you can start construction.
I can start construction, my lord.
But
If I do
45 days or within...
that is my entire point, my lord. Why to have 45 days for registration? I have to do a registration before I sell.
Do you make a declaration while having your building layout plan approved?
Yes.
That you are going for this before the development authority? Do you make a declaration before you get your approval for building layout plan?
My lord.
That you are going to have this building constructed for this purpose?
The purpose need not be shown for
Oh, that is precisely, my lord, because you have to mention whether it is a commercial or a...
No, commercial or residential, I'll have to mention it.
Yes,
commercial or residential, I'll have to mention. But whether I'm selling or I'm only, I keep the ownership and I give it on rent, the development authority is not concerned, my lord.
So show us one plan.
I'll give it to you, my lord.
That was not for the purpose. It is not mentioned in the plan that it is for the purpose of sale or...
My lord, to the best of my ability, my lord, I must say, to the best of my ability, my lord, that's not what they are concerned about. They are concerned whether it's residential or...
What do you declare?
It's a residential or commercial building, my lord. They look at whether it's a building is residential, commercial, whether it has setbacks, whether they have all the proper amenities, all the structural positioning. That's where they are concerned. My lord, I can give you, your lordship, I can...
May I come in for a second, my lord, at this?
Yes.
Well, the purpose, definitely there's a purpose for this 45 days period. Well, once you take a building approval and keep it pending, then if you want to modify it, there's a section 14. You just can't keep it pending like that and decide today I'm doing for a commercial one, tomorrow I'll go for a residential purpose. So that is the purpose the moment the building approval plan is given, you have to register within 45 days.
No, my lord, I completely bow down, my lord, what it felt. My lord, she says there is a purpose of 45 days. Let the purpose be clear, my lord. That is my entire point. The purpose is not clear. That what do they want to achieve within 45 days? And why a penalty beyond 45 days? That's what, that's a query, my lord.
No, but why will you not? That is also a question.
My lord, my lord saw Regulation 3. Regulation 3, my lord saw. Regulation 3 clearly says every application for registration of a new or ongoing real estate project. So I can also, after getting a building approval, I can start constructing. Yes. After 6 months, if I go and register, you say no, there is a penalty.
No, you should apply.
I'll apply. My lord, if I'm saying if I apply, I'll construct.
Why should not apply?
Well, by then I have not decided to whether sell or not.
You have already got your plan approved.
Approval for either residential or commercial, not to whether sell or not. My lord, I can construct a building, even a residential building, I can give it to on rent. My lord, may kindly envy, sir. My lord, if today I have a small land, I construct, I make more than 8 apartments. More than 8 is comes under RERA. My lord, I make more than 8 apartments. I am not building today with an intention to sell. I will make it, my lord. Somebody who has some savings, he will make the building.
That cannot be generalized.
No, my lord.
That cannot be this thing general.
But
Yes.
my lord, that is my humble submission. That is what the parliamentary wisdom was. That is why Section 3 did not have such a clause. Section 3 and the parliamentary wisdom was clear that there are other situations as well. So they said that, listen, you can construct whatever you want, but the moment you decide to sell or advertise, you have to get yourself registered. No question asked. If you're more than 8 and you are trying to sell even part of it, you have to go and register.
So let us see what are your pleadings, what has made you approach this court?
My lord, I have stated, my lord, in para 6, my lord, at page 9. I can also place the building plan approval your lordship wanted, my lord, para 6. My lord, has it, my lord, page 9? Para 6 to para 12, my lord, I have taken those grounds.
Yes.
My lord, may I state, my lord?
What has made you approach?
Yes, my lord.
This must be with reference to some project.
My lord, not exactly one project.
Which project?
No, my lord, not on one project. This is, my lord, this is a association of promoters who have approached your lordship, my lord, because there was issues faced because, my lord, what had happened was because of these conditions. Now, my lord, they were forced to register, otherwise there will be penalty. Whereas they didn't have an intention of doing it at that moment. Now, my lord, that is why, my lord, may kindly see at page para 7, my lord, page 9, we have said that in view of the above, the mandate to register the project within a stipulated time period, irrespective of the fact that the promoter neither wants to advertise nor market, book, or invite persons to purchase, runs contrary to the objective. Now, my lord, may kindly see, in other words, the absence of stipulation. Now, my lord, may kindly have para 10. That the impugned regulation 13 is also devoid of many relevant factors connected to a successful execution of a project. That, for example, market demand, business landscape, and demand supply dynamics at the relevant time, financial viability of the project, and solvency of the promoter. That the impugned regulation 13 is the nature of a compulsion for the promoter who, irrespective of the above compelling factors, is bound to register the project, else will have to suffer huge financial burden by paying hefty amount of fine in cash of deferment, even when it is a decision of the promoter to not to proceed with the advertisement, marketing, booking, selling, or offering of the sale of the project owing to the market dynamics. That it is further submitted that such an amendment acts as a disincentive to the promoter and prejudices the interest of the promoters and likely to put the future of real estate promoters, my lord. Now, my lord, also say that.
Yes, please.
My lord. We say that, my lord, it's also pertinent to that the amendment proves to be a serious barrier upon entry of smaller players, my lord, because we have. My lord, my entire point is, my lord, as I said, my lord, now section 3, the central statute, does not link registration of the project to getting the plan approval, my lord, building plan approval. It says, irrespective of building plan approval, if you want to sell, advertise, and so on and so forth, you have to get yourself registered. A. Now, my lord, regulation 3 of their own regulation of the RERA regulation says that even an ongoing project, you can go and register. So if I have started construction and if I go and then register, then regulation 13 stares at me because they are making two different, one who comes before and one who comes after, although they are allowing both of them to do it. It's not that, my lord, the regulation says that only new project will be registered. So registration can be allowed at any time before I do any of these intended acts, my lord, under section 3. That's my humble submission, my lord. If your lordship wants, my lord, I'll produce that building plan approval, my lord.
Yes,
that will
I surely would like to see.
My lord, if your lordship gives me a small date, my lord, I'll produce it.
Yes, yes.
Wherein we are not making any, your lordship wants to say whether at the time of building plan.
And where is that act? Which deals with sanction of plan? Which act is that?
My lord, that's Odisha Development Authorities Act, my lord. That's
then-
that, my lord.
Which provision
I'm sorry.
deals with approval of plan?
My lord, may.
No, we are seeing this, there is a provision,
My lord.
not from the object of the act.
My lord of the Odisha Development Authority.
No, from the real estate.
Yes, your lordship.
To make registration of a real estate project compulsory
Yes, your lordship.
in case where the area of land proposed to be developed exceed 500 square meters.
Absolutely, my lord.
Or number of apartments proposed to be developed exceed 8.
8. Yes, your lordship.
So it says registration of real compulsory in case the proposed to be developed.
Yes, your lordship. Yes, your lordship.
So the moment you get your plan approved,
My lord.
you propose to develop.
My lord.
All right. So that is there. You will see the provisions also.
My lord. My lord, section 3(2) also says that, my lord. 3(2).
There is difference between 3(2) and the and what is there.
Object, my lord?
It says yes, object.
I understand.
Finally we will be guided by the
Absolutely, my lord. I completely bow down.
statutory
The aims
provision,
and
not
objects
by the-
also. Yes, sir.
It says that to impose an obligation to make the registration of real estate project compulsory
My lord.
in case where an area of land proposed to be developed exceed 500 square meters. So this is proposed to be developed.
My lord. My lord.
Right.
Yes, your
So
lord.
that registration is required when it is proposed to be developed.
Yes, your lordship.
When it is proposed to be developed, the moment you get approval of your plan.
So,
All right.
Yes, your
And
lordship.
therefore, in that background, that regulation is there.
My lord, if your lordship also looks at 3(2), because 3(1) your lordship saw, my lord may kindly see 3(2) at page 53. I just wanted to make it clear, my lord. 3(2) also says, notwithstanding, my lord has it, my lord? Notwithstanding anything contained in subsection 1, no registration of real estate project shall be required where the area of land proposed to be developed does not exceed 500 square meters or the number of apartment proposed to be developed does not exceed 8 inclusive of all phases. So, my lord, it's in reverse, it's in negative. So, it need not be
That is different.
correct. So, now, my lord, also, my lord, see 2C. That is why, my lord, say 2C, my lord, kindly see. My lord was looking at 2A. For the purpose of renovation
2A or 3A?
My lord, 3(2)C.
3(2)C.
Yes, your lord. For the purpose of renovation or repair or redevelopment which does not involve marketing, registration, selling or new allotment of any apartment, plot or building as the case may be under the real estate project. So, my lord, I understand your lordships, what has fallen from your lordships, but my lord, 3(1) and 2(C), my humble submission is, makes it clear that what is the intent of the act. Your lordship, I understand what has fallen from your lordship, but section 3(1), which says all these, and also 2C, which says that if you're making something which is not for marketing, advertising, selling, then you need not register yourself. So, my lord, there has to be an interplay of section 3(1) and 3(2).
See, therefore, if you don't intend,
my lord,
then you are not required to register.
Absolutely.
You don't do.
My lord, my lord, that's
See,
we all agree
today,
to that.
today you plan
My lord.
that you get approval
My lord.
of your plan.
My lord.
And tomorrow you are saying that I don't have any intention.
My lord.
Now, after 5 months, you say that now I have intention, now I am going to
Now, my lord, what will be clear is only, my lord, if what I understand completely what has followed, my lord. So, if a plan can be examined, and if in a plan a person says I'm proposing to sell, then your lordship, I have no case.
So therefore, we are deciding, we have to decide on facts.
Absolutely, my lord. No, my lord, I'm only saying that if your
Therefore,
lordship.
you have just come to have a declaration from the court in abstract.
No, my lord, I tried my best to submit what. Now, my lord, give me one chance. If I'm
no cause of action.
My lord,
You may challenge the provision in some other.
my lord, may kindly give me one chance, my lord. If
Not in this case.
no, my lord, if I can produce a approval.
No, someone this is there can be individual cause of action. Some promoter may come. Otherwise, this association coming to challenge the.
My lord, may give me one chance if I can produce a building plan approval.
Building plan. Whose building plan?
My lord, one of our members' building plan.
Oh, your member's building plan. In the other building plan, he may.
No, my lord, all building plans are the same, my lord. All building plans are one particular format, my lord. And in the building plan, there is no declaration that I'm going to sell.
If you are inviting us to write, we will write. When do you want?
No, my lord, I'm not inviting.
No, please.
I was just asking if your lordship is gracious enough to give me one chance, my lord.
No, we'll decide it. We'll decide. It's a question to be decided.
I don't want to invite the wrath of your court. I'm sorry.
No question of wrath. We are bound to decide the cases on the basis of law. When we have a tentative opinion, we may change our opinion. We don't know.
I completely bottom. If one date, my lord, I can immediately. Whenever your lordship is convenient.
But that day, please don't make any prayer for withdrawal. This assurance you must give.
My lord, that is why I said, my lord, I don't want to invite your lordship's wrath.
No question of wrath. We don't do it. We don't do that. And where is the question? Even what will happen? Maximum we may dismiss your application.
I bottom.
How do you say that I don't want to invite our?
No, my lord, because your lordship said don't say withdrawal, then I will not withdraw, my lord.
Yes.
No, my lord, I will not withdraw, my lord. I'll not withdraw, my lord. I'll file a
hearing on behalf of the petitioner seeks short adjournment. Stop this matter on when
next week, any day at your lordship.
Who is appearing for? You are appearing for.
RERA
for the state. RERA has a different.
RERA, Mr. Bibhu Tripathi appears.
VP
If your
Tripathi.
lordship says, I'll give him copies.
We will see. It is required. May come.
No
We are not
need to
saying
serve
anything.
Wait for me. I'll give. Deeply obliged, man. Deeply obliged.
My lord, I'm sorry, my lord. It's very urgent matter. That's why I'm mentioning. This is a matter, my lord, under a contempt, my lord, where the honorable single judge, my lord, he directed the SP Devgar to produce the lady ADM tomorrow morning at 10:30, my lord. That lady ADM is the nodal election officer, my lord, and she's totally controlling the elections, my lord. That matter was not in the list, my lord. It was taken at 2 p.m., my lord, and there is a direction to the SP to produce her, my lord. So I filed this IM, my lord. This may be taken up on the last hour, my lord. Do you have a copy of the order? No, my lord. This order just now at 2 p.m. my lord, the matter is taken, and this type of order has been passed. I'm very sorry, my lord. No, but what have you done? No, nothing, my lord. It's the first date, my lord. It's a arrangement out of a service matter, my lord. And a writ appeal is also pending before my lordship's, my lord. There is a writ appeal number 886 of 2024, my lord. And direction to the SP to produce her, my lord, for tomorrow morning. Very disgusting. And now the election one nomination. From today, it's a nomination started. What was the order? Well, to direct the he has directed the SP. No. What was the order? Well, order was to comply in respect to the appointment of a principal of the college. They have got a women's college, the secondary college, to appointment of an principal. The principal was removed from that post in the year 2020, and he has challenged. But he was involved in nefarious activities, so the director has removed her. No, but why did you not implement the court's order? The court order has been implemented, because the writ appeal is filed, writ appeal is pending before this honorable court, and this order was passed on the last week of January, Then after writ appeal is filed, What is the number? That is 886 up to 2024. 886 of 2024. And this number, complete number, is we have received 1 day before, on Saturday. It was in defect. No, statement, the principal.
Notify. Notify. Well, we will see.
Yes, ma'am. Copy.
Copy of what?
Well, this IA, man. We have a IA to this order which is passed just now at 2 p.m.
We will see, let the,
That
come. Huh?
But,
So this IA you have filed where, in which case?
in that WM, my lord, but in respect to the present order, my lord, I mentioned it.
All right. Learn Advocate General to be here.
Yes,
Yes,
I will,
yes,
I
yes,
will. And that writ appeal,
No, writ appeal has been filed by them, not by
No.
the state.
There is a principle.
is it with them?
Yes, we have served the copy. Previously, we have served the copy. We
Who
served
has
the copy.
filed? Who has filed the writ appeal?
This is the principal of that college, my lord, who is one of the party, my lord. ADM is he is the president of the governing body.
After all, he is your officer.
Our officer, but also, don't know, we'll find out, also. I will get the number and find out.
We will take up that matter at 4:15.
Yes, sir.
But I pray my last week by the translation copy I have not given. Day after tomorrow, my lord, at least. Translation copy that the Oriya version is there, the representation. So that's why day after tomorrow, my lord. Yeah, matter about that is the query lease. Query lease for sand query has been notified by the state government under section 15 of the Mining Act and not by PLM, my lord, the Gram Panchayat persons are coming to my lords to stop it as because that is.
Yes, this is a PIL.
So that's why my lordship, I will give the translation copy, my lord will consider. That is just PIL, my lord, seeking my lord to stop such a query lease as because it will harm the embankment and the total area where there is some location. I have stated all the grievance before the Deputy Director of Mines, Jaspur, and Annexure 2, page 17. It is the Oriya version, my lord. I have stated all the things. Grievance is pending before him. It is for a redressal, but it is also completely the violation of the mining rule 4. That is without recommendation of the Gram Panchayat, they have also insisted and in a.
My lord, his grievance is that by virtue of this annexure 1, a bid was invited from various intending persons to lease out a sand quarry. He is representing some of the villagers. He is saying that if the sand quarry is leased out in favor of somebody, that the villagers will be affected. That is the sum and substance of his allegation. And as your lordship will find in annexure 1, the date of bidding is already over. So it must have been auctioned in favor of somebody. That is the allegation of the petitioners. We'll file.
Item 13.
2 weeks. These are.
Mining.
Item note 13.
My lords, I am for the petitioner. My lords, we are here assailing the order dated 11 December 2023, passed by the respondent number 3. My lords, here we are challenging the virus of the notification issued, which under section 168A, which has given the extended time to adjudicate to the authorities. My lords, similar matter, my lords have given interim protection. My lord, the matter I request if maybe tagged, my local advocate is there in the court with the relevant orders of my lords.
The similar matters are pending.
Similar to matters, yes.
Section
Yes, my lords.
168A.
My lords, Rahul Ray is there in the court.
It was
Ashweta is there in the court.
posted to, might have been.
My lords, Dish Infra.
15th like this. My lord might have been 13th. Something. 13th. 9th. Sorry. 15th or 9th, yes. 9th.
Second May. Even second May, man.
Second May.
You have not checked up the up-to-date position.
Lordship,
You have not checked up the up-to-date position to which date those matters have been posted.
You could have told us that what is the date fixed for those questions. How can you find out?
apologies, Your Lordship.
How can you find out?
In the website.
You provide us in the order today, just now.
Yes, Your Lordship.
Is the date mentioned in that order?
Yes, Your Lordship. Just below the order.
The date is 9/4. The subsequent date you have not.
You should have read the order before.
Deeply pardon, Your Lordship.
Could you find the date?
Yes, Your Lordship. It is a mistake on my part.
We also use.
Yes, Your Lordship.
Yes.
Item number 14.
May I please, Your Lordship? Here the petitioner before Lordship is a existing nursing college miller, and the petitioner had made application for granting NOC for the academic session. The current, Your Lordship, may kindly, what extent of callousness on the part of the opposing party? We have no laches, Miller. I will invite Your Lordship attention to Miller. Your Lordship is giving liberty to make fresh application in identical footing, Miller. Your Lordship may kindly have a glance.
That date has crossed.
Miller, because for they have still matter is still pending for consideration.
No.
At their steps, Miller, they have not taken any decision. That is my case, Miller. It is because of their laches, Miller, I am unable to make application for renewal. Miller, my matter is I have made the deposit, Miller. I have complied everything, Miller. Your Lordship may kindly appreciate Annexure 3. I will clarify, Your Lordship, there is no laches on the part of the institution, Miller. Supposing if they had issued NOC in my favor, Miller, then I would have a chance to make renewal application. It is still pending, Miller. There is no laches. Your Lordship may kindly appreciate Annexure 3, Miller. Under similar situation, Your Lordship has been pleased to grant liberty to petitioner make application.
But this is what is subject to the provision.
X, Miller.
The timeline.
Your Lordship may kindly appreciate the very case of the petitioner before Lordship. Your Lordship may kindly come to Annexure 3. That is at page 22 of merit application, Miller. It is a letter from the side of the authority. It is the register of ONRC, Miller. Odisha Nursing and Midwives Council, Miller. That is OP number 3, Miller. In responding my application, Miller.
We cannot go back
Miller.
to that period.
Miller.
Now the question is of 2024-25.
Miller.
Whether.
Time is over, my lord.
Miller, they are obliged to take a decision, Miller, in pursuance of my application and all compliance. Till that, they have not taken any decision, Miller.
23-24.
Yes, Miller, 23-24, it has.
Then what should the court do for that period?
Miller, because of their callousness, because of their inaction, Miller, I am now prevented to make application for further year, Miller. Miller, because I am waiting for their decision, Miller.
That count.
Well,
We not make an application for 2024, 2025.
Well.
As per the date,
Well.
then you are to be blamed.
Miller, there was no scope, Miller, on our part.
Don't enter into argument like this.
Miller, that was not, that's why your lordship had appreciated the case of identical nature, that is the case, Miller. And it was the order, if your lordship will dispose of in light of this order, Miller, the petitioner can get some relief, Miller. By any other.
And so to the appropriate liberty and observation.
Miller.
That is any such application when it is.
Jordan,
that this will be a person expeditiously in accordance with law, keeping the time line in mind.
Item 15.
May I please, Lords? The public interest litigation filed by the one of the villager lordship challenging the inaction of the opposite party authorities, it's allowing the OP5 to set up a factory lordship that is ready mix cement mixture plant in the residential area lordship. Residential area adjacent to the village school, Anganwadi center, and the using the proposed land lordship where he is constructing, there is no approach road to the public road lordship. And the annex of 2 lordship, the government road, which is reserved for the club lordship, using and encouraging that plot lordship, he is installing the factory lordship, the residential area, the for which lordship, the present petitioner villagers is large number of annex of 3 lordship. They have repented to the authorities lordship, opposite party authorities to look into the matter, but they have nobody is listening the grievance of the villagers lordship for which this PL has been filed lordship. The lordship know the cement factory lordship, the pollution level is so high so far cement factory is concerned, which cannot be permitted on within the residential area lordship. And annex 3 lordship that is pending before the all the opposite party authority lordship. My lord.
You will not direct for disposal of your.
Yes, my lord. Lordship.
So you file this representation on when?
That is the lordship with 31st January lordship.
And when you file the
Read questions file lordship on 18th March lordship.
only for the purpose, you file this representation only for the purpose of filing the representation. And where before whom did you file?
That is before the collector lordship, collector and Tahsildar as well as the pollution control lordship, secretary pollution control board lordship.
You could have pursued, you could have. Why should you come to the High Court?
Without taking any permission from the authorities and construction is going on, and if the factory will set up a lordship, then it is create public hazard to the public hazard to lordship. Essential lordship December lordship. After if he has trying construction lordship, the villagers are trying to obstruct them lordship. My lords?
Yes, when the construction.
That is since December lordship.
Where have you?
Specifically, I have not stated lordship, but in The villagers have also initiated 133 proceeding before the learned executive magistrate, which is also pending before lordship. They are also not taking any step.
When the construction is going on, then what and when the construction is going on?
Since December, lordship. Specific date I have not mentioned, lordship, but after initiation on February 1st, lordship, 3/2/2024, lordship, I have filed 133 proceeding before the executive magistrate, lordship. That is, I have avoided in para 15 of the writ application, lordship.
Then you have grievance against some of this for private party.
It is a private OP5, lordship. This PIL, lordship, kindly consider the installation of that factory, lordship, cement factory within the residential area. It is creating. Yes, already approached, lordship, but they have not taken any step, lordship. Since January, lordship.
January, and you have come here in March. Where is that?
That is, lordship, Annexure 3 series. Lordship, kindly have a glance, and that is in Odia, lordship, page 25, lordship. Page 25. Since 31st March, through post, we have sent, lordship, with photo of the area, lordship. Page 29 is the. My lord.
Saying December, this cannot be December construction.
No, my lord, this is the adjacent plot, lordship, where the school and a Anganwadi center, that is there, lordship, and a clubhouse. 3 adjacent to the proposed factory, lordship.
My lord, it is purely an apprehension, my lord. They're saying that he will operate, he will install. Your lordship may see para 7, 8, and 9. I think, and he is doing that. Their allegation is it is his plot. It's not on any gov. It is in his plot that he is going to operate, he is going to install.
My lord.
Is the factory there?
Yes.
Party number 5. Block of land belonging to him. Which has all serious pollution issues. And adversely affect movement of the villagers. From the readings in the petition, it appears that for this party number 5, that nothing from the readings from record, nothing emerges as to what step opposite party number 5 has taken to establish a cement ready-mix workshop. The writ petition, the petitioner that we have approached authorities also in this regard.
in this court's opinion, this application is premature and result will be dismissed on that ground.
Item number 16.
Your Lordship, if I may be allowed to just make one submission in the previous matter. Your Lordship, to answer the question, on 6/4/2024, the matter was listed and the next date was given to 9/4/2024. However, subsequent to that, 4 dates passed, but the matter could not reach. However, on 25/4/2024, the matter was specifically listed on 4:30 p.m. and then it was subsequently tagged along with the other matter that that your Lordship was provided with the copy of. And then the subsequent date is on 2nd May of 2024.
Thank you.
Much obliged, your Lordship.
My lord, here two cases are there. That's it regarding grant of NOC, but in this case, NOC has been granted. It is separate stand. In my case, my lord, item 17 may be taken up a lead case.
Again,
No, PIL, it is regarding grant of a NOC to the educational institution, just my lord. In this case, my lord, peculiar situation, my lord, item number 17 may be taken up as a lead case, my lord. Two cases, 16 and 17.
what is the number?
17 is the 10026 of 2024. Item number 17.
Item 17. Next.
What do you want?
My lord, in this case, my lord, page 23. My lord, page 23. NOC has been granted to me. It was granted on 23 February. There was, the NOC is at page 23, my lord. The page 23 reads, my lord, the NOC is valid for 1 academic year and the institution shall not admit students more than the approved intake. So I am getting the NOC for 1 year from 23 February. But when I admitted, at that time, my lord, the peculiar circumstance is that at that time, my lord knows very well that the date of admission was over. So by that time, I was granted the NOC. Since I cannot admit the student online, I collected the students and admitted it on management quota. And thereafter,
Prosecuted.
my lord,
He should be prosecuted.
no, my lord, that was till 28.
Yes.
That was till 28. So for uploading the data, my lord, for uploading the data, for admission was 31st. For uploading that, it is 28 February. So when
was the NOC granted?
NOC was 23 February, my lord.
23 February
2024, my lord.
24.
My lord.
And what was the last date for admission?
Last date for admission was 31st January.
Did you admit any student?
No, at that time I did not because I had no NOC. But after I got that NOC, I admitted the students.
So last date was 31/1/2024.
My lord.
You got NOC on 23/2/2024.
Yes, my lord. Obliged.
And thereafter you have admitted students.
My lord.
Therefore, we are observing that you should be prosecuted.
No, my lord, there was 7 days time for uploading. It was 28 February for uploading the data.
How should you admit? Where is the question of uploading?
My lord, NOC was granted to me for admission, my lord. It was valid for 1 year.
After the last date for admission.
Yes, my lord, I have no fault, but it was granted by them. Previously, my lord, it was being extended from time to time.
How many students have you?
My lord,
How many students have been?
it was 15 to 20 students.
Then you have to compensate.
No, my lord, my submission is that since NOC was granted to me, it was not my fault, but it was granted by the authority in my favor. So I may kindly be permitted to upload the data because they are allowing, my lord, that it is one of the letter, my lord. In the previous year, they are allowing for admission, for uploading the data, they have extended the data, the deadline for uploading the hard copies because we cannot use online. It was closed, but the document to be supplied in the hard copies before the authorities.
So I may kindly be permitted
You
to
will upload what?
the name and details of the admission students.
After the cutoff date.
My lord, NOC was granted to me, but my lord, that was the condition, my lord.
You cannot take admission after the cutoff date. That is the law.
Lord, they should not have granted me NOC, my lord.
That should be automatically renewed for the academic session 24th.
You also want automatic grant of NOC for subsequent year.
No, that is second pair. I am that my lord has directed the representation. I shall submit the representation. That will be considered. That is the second pair.
That is first prayer also.
The first prayer is to allow me to admit the student.
Since the time limit for renewal of NOC has expired on 15/12/2023.
Yes, my lord. Yes, yes.
The deadline for renewal should not be extended.
That is for 24-25.
To allow.
That is for 24-25, which was my previous, my friend was dealing with. I will submit the representation. That will be considered as per my lord's. My lord.
We are dismissing your because we could not have admitted this one.
My lord, it is the, my lord, I have no fault, my lord. Because the NOC was granted by the authority. It was valid for 1 year.
On this ground, you will not be granted NOC forever.
They could have rejected that you should not proceed with or should not that because NOC was granted once. NOC was.
Did you know that 31st was the last date?
No, at that time NOC was not granted, my lord. Once NOC was granted.
The query is whether you were conscious or was it within your knowledge that was the cutoff date for admission.
At that time, it was, my lord, I know that, but NOC was not granted. I could not admit administrator. After that, NOC was granted, I came to know that that was the 31st month, but uploading for the data, there is 28th February. So only 5 days left. My lord, one surprising matter is that I got that NOC also.
Okay, here.
I may kindly be permitted to file a representation, my lord, they may consider that. My lord?
No representation.
My lord, future of the students may be taken into consideration, my lord, it is the, my lord.
Future of students, we are thinking of your future. Future of the institution. You are not interested in the future of students. Not a question of future.
So I may kindly be permitted to withdraw, my lord. Both, my lord, 16 and 17.
Item 18.
Agree. I'm going to prepare a chart. I take your lordships to the guideline, that is annexure 1 at page 19. Move copy again. And you also kindly look page 21 of the guideline. This is a post-diploma in industrial safety. That course is post-diploma in industrial safety. And if you also look to page 21, the land, the institute may be permitted. This is way back in 2009. This guideline is still in force. The land institute may be permitted to be established with the norms as per the following. City area 0.5 acres. And the building, the specification building is there. And you also see the norms of for post-diploma industrial safety, that is in the top. The institution may be started with maximum 60 seats, which can be increased in 30 numbers per each year for a maximum 120. Seeing the interest of working executive, second shift may be allowed 7 seats to a maximum 30 number of seats in first year, which can be increased for a maximum 60. Then also kindly come to page 23. A inspection was made by an experts, that is page 23. You'll also kindly come to page 28, the recommendations. Page 28, they verified the lands as well as the building. Page 28, you also see the area required as per the land category, that is 0.5 acre, and the total area available, so far the petitioner institute is concerned, 1.09. That you also can find out from page 28. Likewise, page 29, the infrastructural building, the requirement is 300, available is 300 square meter. Likewise, the other 240, 242, everything is satisfied. And page 33 is the permission which was granted. Page 33, post diploma in industrial, 30 seats was given way back in 2011-12. Also kindly come to page 33. The experts report, they recommended post diploma in industrial safety 30, intake capacity, period of approval is 2011-12. And if you also will get at page 35, the government letter of approval, page 35. Approval for new institute industrial safety for the academic session 2011-12. So far the petitioner institute is concerned, serial number 7, Sivanand Educational Trust for Social Advancement, 30 number of seats, also kindly mark it. Permission was granted for establishment of new institute to conduct 1-year post diploma course, 30 first shift, that is in 2011-12. And if you also will look to page 36, these are the conditions. 36, permission was granted with subject to these conditions. And this condition, after being satisfied, will also kindly come to page 37. Page 37, extension of government approval in respect of existing institute of diploma in industrial safety for the academic session 2012-13. Earlier it was given 11-12, then 12-13, 13-14. Like this, the Aerospace State will come to page 42. Till 2021-22, they granted 30 numbers. They established the institution and appointed the staff, infrastructure are developed, everything is there. So in 2021-22, Annexure 3 at page 42, they made, because they wanted to enhance it, and from 30 to 60, they made this inspection that that is at Annexure 3. You also see the top 2021-22, and these are the experts. And if you also will come to page 46, the recommendation at page 46. That is on 12/8/2021. That means right from 2011-12 till 2021, 30 seats were there. From 2021, August, they recommended for 60 seats. You also come to page 46, last line. The considering the infrastructure, the intake capacity of the be enhanced from 30 to 60 per year. That is the recommendation at page 46. And at 49, page 49, you also see that 60 seat that was enhanced to 30, from 30 to 60. That is page 49, serial number 10, Sivanand Institute of Industry, 60. Page 49. Page 49. That starts, the information brochure starts from page 47. Relevant page is page 49, serial number 10. Serial number Sivanand Institute of Industrial Safety at so-and-so, district Angul, 60. That's see right hand column. That means it was, instead of 30, it was enhanced to 30, a 60, another 30. And from 2021-22, they admitted the student, appointed the staff, 21-22 and 22-23. Then what happened at page 51, some allegations, some outsiders made some allegations in respect of the rest 30 number of seats, enhancement of seats. And if you also will come to page 51, again, an expert committee visited at page 51. And the date of visit is 2nd August 2023. And if you also will come to page 61, they made a recommendation that you also come to page 61, satisfactory so far 30 intake is concerned, but 2 below satisfactory for 60. That means the rest 30, the existing 30, They said that,
You are referring to 61.
yes, sir. Yes, sir. Final assessment by the expert committee, the bottom top. So far, my institute is concerned, Sivanand Institute of Industrial Safety. My name is there. And if you also will see the capital B bottom, overall grades, excellent, very good, satisfactory, tick mark, satisfactory. But it has been written in a satisfactory for 30 intakes. Then 2, Roman 2, below satisfactory for 60 intakes. I think you also get it. Now, you also kindly come to page 67. They said they, in fact, recommended that certain deficiency are there in respect of 30 seats, 30 number of seats out of 60. That is at page 62. Reason for not recommending 30 out of 60. 1, 2, 3, 4. These 1, 2, 3, 4. So page 62. You also see the bottom, the institute not recommended. You also get it, not recommended 30. The institute is not recommended for 60 intakes. 30 out of 60. Reason for not recommending 30 out of 60, these are the reasons which the petitioner can satisfy, can take time. That's different. But at this juncture, at page 67, I am concerned with page 67. Now they have.
There are 4 reasons given.
4 reasons are given. I am not also raising those points at the present moment. Those are for the institute to be satisfied or not. But so far the 30, existing 30 is concerned, at page 67, they wanted to stop the entire admission. That is, you also see page 67. Inviting a reference, director's letter to the chairman, Petitioner Institute, madam, inviting a reference to the subject cited above, I am to say that joint inspection of your institution was done by 2 members of the inspecting officer as representative of DTET. They had recommended reduction of intake capacity from 60 to 30 due to deficiency like unavailability of required laboratories and safety equipments. The joint inspection report was placed in the past Apex Diploma Admission Committee meeting held on 13/3/2024 under the chairmanship of the Principal Secretary to Government in SD&T Department, Government of Orissa. The committee decided to keep the admission in abeyance with effect from WRT, your institution, in PDIS course in the academic year 2024-25, keeping in view the quality of education. That means they have stopped the entire 60 number of seats, as a result of which the institution will be closed. There is no dispute so far as the existing 30 seats are concerned, which had got it way back in 2011-12. And from 2011-12, infrastructure has been developed, building has been constructed, area they have satisfied time and again. And in fact, in the last inspection also, they are satisfied about those 30 seats, but they have now stopped the entire. That is my entire case. So far, the enhanced 30 seats is concerned, that is the matter which the institution may satisfy the requirement. Whether they will do it or not, that's a different question. But the 30 number of existing seats which has been granted last from 2011-12 till today, if that will be stopped, then all my infrastructure, the staffs and everything, now the admission is going on.
This now, unless 8 and by total attendance.
Yes.
1 week.
My only problem is the admission is going on. They have, of course, they can extend the date, but the last date they have kept it to tomorrow. But so far as the spot selection or other selection, that is still there. So if my learned friend will at least take instruction a little bit earlier, so that matter can be disposed. This is a limited point. Yes, in respect of the 30 seats, can I also make some 30 seats? I don't say that about 60 seats. 30 seats, there is no dispute about this. If your lordship will allow the petitioner institution, at least they will make request them and they let them at liberty be granted so that process only the name of the institution will be enlisted in the website for admission in respect of 30 seats. And last date is tomorrow. Tomorrow.
We can take up the matter tomorrow. for passing.
Yes.
Order is required.
Ma-
Instruction, oral instruction.
Yes.
Then we may admit. Because he is right.
With
that
regard to 30.
This is allowed to continue, and if the date also process, then it will become impossible. So, provisionally, they can be.
Yes.
And the students to get admission, they will also be informed that the admission is provisional, subject to final. If not only please to get up the land tomorrow after lunch, then by after lunch, they will have this.
Yes, yes,
But in the
certainly.
meanwhile, if you can conditional thing, allow the institution to admit. And if you are of the view that even provisionally they should not be allowed, then we will adjudicate and see what can be. We are not making further offers.
My appearance, Mama.
Item number 19. Okay, my lord. All have been complied, my lord. Item number 20.
Comply ହେଇଯାଇଥିବ 100% sir. Comply ହେଇଗଲା. Fees ବି ପାଇଗଲା
Item number 20.
Orders have been complied with. Lordship's recommendation has been made for the payment of enhanced compensation 28A.
Given the list of the cases. yes,
Well,
the orders have been
complied with. I have not informed my office.
So
I.
those cases can
Yes.
be listed and can be.
Yes, sir. Yes.
That's all we.
Item 21. Item number 21.
Yes, sir. I filed the compliance affidavit on 23rd of this month. It was stated that orders have been complied with.
There is no limitation of doubt. Plans of the week can be filed on behalf of.
Item number 22.
For 22 also filed my compliance affidavit not on 26, wherein I have stated that order has been passed by the Tahsildar Binka. Yes, 22 million.
My lord, I may be permitted to appear through VC, my lord. I am for the petitioner, my lord.
23.
22, my lord, 22.
Yes.
My lord, they have served the compliance affidavit 2 days before, my lord. We have sought for some instruction from our client. My lord, let it come next week, my lord. May I pray, my lord?
What was the order?
Lordship, can you look at the order?
The order has been complied with it very.
Only my lord, sir.
And if you are very given to the challenge.
No, but we have stated that there are encroachments and we are going to make it free from encroachment.
After examining the petitioner's application, order has been passed. Steps have been taken for removal of.
No, order has also been passed. No, order passed on 24th of April.
Item 23.
23 minutes. There was a direction to consider the representation annex of 3. Listed for the first time April, also grant me some time, I have to obtain instruction.
Time allowed. Order dated 2010.
Item 24.
Mallards non-comply of order. Non-comply of order 29/11/2023.
No, sir. For the first time it has come last. Here also, there was a direction to dispose the representation. 2 weeks time also, in the meantime, I will produce.
Orders item 25.
The file has not come.
415 also there.
415.
Let it come, I will.
Item 25. Item number 25.
Yes, wait for the state. Before is not. Open the weekend. 2006. There's some on demand. 14 Mallots, 11/8/2014.
Flag B. Page 807. Honorable Apex Court has given some directions thereafter. Another bench has remanded the matter in 2014.
They were searching for the petition of counsel so that
On 19th February 2014, a judgment was passed by a division bench of Honorable Apex Court. Thereafter, in August 2014, three judges bench of Honorable Supreme Court have remanded this matter.
Please see. Tell us, I'll find next week. There is no representation of.
He's seniorly. Kali Prasanna is senior advocate now.
Item now 26.
A copy of the petition has been served just now. In just 2-3 minutes we go.
Copy of the writ petition.
No, copy of the IA, which is listed today for orders. That is not maintainable, however. But 3, opposite part number 3, bank.
IA number 1889.
Correct, 1889. 1889, IA number 1889 of 2023.
When do you want?
Any day.
Let me make 1 week. 1 week, 1 week.
Supply time, 1 week after any date.
8 years. You get the date.
Item 27.
May I please join us? In this case, I have filed one interim application number 5243 of 2023 minutes. But praying for a modification. What has happened, your Lordship may kindly see, plus page 7, the order passed by this honorable court, my lords. Page 7.
7 of IA.
Page 7, IA, my lords.
Yes.
Order dated 2/2023, my lords. It is seen that despite notice having issued in this petition way back on 20th March 2018, this is passed in another collateral matter, my lords. Till date, no reply is received. Last opportunity granted, department to file reply within 8 weeks. Rejoinder in the meantime. List this matter along with WPC 3529 of 2018 on 16 May 2023. 3259 is the matter which your Lordship is holding the brief now. Arising out of this IA, arising out of WPC 3529. Your Lordship directed that matter to be tagged along with this matter. Then, my lords, matter next came up on 9/2/2023. My lords may kindly see page 10, my lords. Page 8, next page. Page 8. Your Lordship, by order date 9/2/23 said, on being mentioned, because that was the date matter was listed for hearing, my lords. It's a batch of applications are there. And this matter was there in that batch. On being mentioned by the Law and Council petitioner, this matter be delinked from WPC number 13736 of 17 and listed separately on 11/9/2023 in the regular list. That your Lordship directed because different matter, not connected to a batch, your Lordship directed delink and separately listed, my lords. The batch of matters, on that day was heard, judgment was reserved. Subsequently, judgment pronounced. But instead of this being delinked, this number finds place in that judgment, batch of cases. For that modification, that judgment was challenged by this petition before the Supreme Court. The other day, I have given probably a copy of Supreme Court decision, maybe on record, and copy I am giving to Lordship. My Lordship may kindly bear with me. This SLP filed against the judgment in which my name was also there as one of the parties there. My Lordship may kindly see. It's the first page. We have heard, let me place with the Lordship permission, my lords. We have heard Law and Council petitioner. Law and Council petitioner submitted that the High Court by an order dated 9/2/23, passed in WPC number 3529 of 18, out of which this special petition arises, was tagged from WPC 13736 of 17 and was ordered to be heard separately on 11/9/23. The order which I read out before Lordship, my lords. However, in the impugned order dated 15/3/23, the detached writ petition of the petitioner has also been included as having been disposed of by the said order along with other connected cases. He submitted that application has been filed in that regard before the High Court and the consideration of the said application awaited. This IM errors. Therefore, submission was made that the petitioner may be permitted to withdraw the special petition with liberty to file fresh petition in case the petitioner has any cause of so to do. The submission of counsel for the petition taken record. Special be dismissed or withdrawn, however, liberty result petition to file fresh application. So therefore, that is why this IA. Only my limited prayer for Lordship is because despite of my Lordship's judicial direction to detag and to separately list it, lords, but somehow inadvertently the number is included in the batch of petitions while to be disposed of, that should be deleted. That is my only limited prayer, lords.
So far as this WPC number 2842 of 2018 is concerned, and the judgment passed along with other cases, that is to be revoked.
Exactly. 2842, I do not know whether that is separate. This is to be removed, yes.
15th March 2023. Stop. Is the case of the petitioner that apparently out of inadvertence in the said batch of cases, the description of present case also finds place. Stop. The judgment delivered by this court in WPC, the judgment, the reported judgment of this court dated 15/3/2023. And has been decided or is pending?
That batch matter is disposed of, yours.
Batch matter is-
13736 is disposed of. This is dealing.
Supreme Court.
That is pending.
Supreme Court
Pending.
department has challenged, I think.
All are challenged.
Petitioner and department both have challenged, it's pending there.
Into the challenge before the Supreme Court giving rise to special leave petition. Then for the
Both the sides they have challenged.
challenge for the Supreme Court. Stop. In the when the matter was taken by the Supreme Court on 14/7/2023, the following order came to be passed. We have heard the present IA, as present this application has been filed. In the aforesaid background for the restoration of WPC number 3529 of 2018 to its original file.
Minus.
Considering the facts and circumstances, the WPC number 3529 of 2018 is ordered to be restored to its original file. So, let the matter be dispute under that of the. That's all.
It can be disposed of in the light of the state judgment also.
No, that is the arguable issue.
No. Now it is restored.
You're right.
No, don't confuse.
That cannot.
You're right.
So all consequential orders which are passed therein, from that, that may be revived, because it is there, whatever is there. Yes, Milos.
All the orders revived.
Correct, absolutely. A line of clarification.
From the batch it is detached.
You're right. Let it be extended for specific days.
If we are not given,
Yeah.
let it be.
Get finished.
Upon special notice, read appeal 886 of 2024.
Yes, what was the order?
Mala, this appeal was filed on 23rd February 24, Mala, and it was registered on 27th April 2020.
Order.
Sir,
SR ହେଇଛି, SR ହେଇକି 27th ରେ number ହେଇଛି. President of the governing body. So this was direction, there was a direction to allow the petitioner to continue.
Yes, ma'am. My lord, can I submit the background of this matter, ma'am? This Prahlad Kumar Dev, he was previously in the year 2020, he was a principal in charge, my lord. And he was involved in some nefarious activities.
Counsel, he might be a dacoit.
Ma'am.
But the question is that when the court directs that he should be allowed to continue as a principal in charge, you have to follow.
My lord, then we have filed the writ appeal, my lord. This writ appeal was filed against
And writ appeal filed and you removed him.
No, he was previously he was removed in 2020.
There was an interim order continuing.
No, my lord, he was 2020. He was.
Sir, please come to paragraph 7.1. But if you have done this, then you should be sent to jail. And the single judge is absolutely correct.
No.
Please come to paragraph 7.1.
It does. Then more file. Seven is the that is a
Please
order.
come to paragraph 7.1.
Can I read out 7.1?
Yes.
In any view of the matter, since without prior approval of the opposite party number 2 and without following the principle of natural justice, additional director issue the direction to the opposite party number 3 to remove the petitioner, and basing on the same, the impugned order dated 22nd September 2020 was passed by the opposite party number 3 under annexure 5. This court is inclined to quash the said order. While quashing the same, this court, taking into account the interim order passed on 9/10/20, directed the opposite party number 3 to allow the prisoner to continue as principal in charge of the college in terms of the order dated 19 October 2021. Against that, my lord, there is a status quo. In that order, my lord, there was status quo, my lord, in that writ petition.
It's a status quo, therefore he was continuing in the light of this order 9/10/2020.
Yes, my lord, because for the status quo, he previously he was removed.
Could you remove him?
Prior to that, he was removed.
Prior to that, he was removed.
Yes,
but because of the order of a status quo, he was continuing.
No, he was not continuing for the status quo. Later on, the status quo has come, my lord. First, he was removed, my lord.
So is this your case that after
Yes,
the order
yes,
of
ma'am.
status quo?
And then after this, Devendra Kumar.
After this order dated 9/10/2020, he was not continuing.
No, my lord, he was not continuing.
Where have you said?
In the para number 9, that in the inquiry, all the faults of the respondent and his illegal act are being cleared, and in his place, the present petition number 1 was entrusted in the post of principal in charge of the college, and since the day he is continuing in the said post.
You are the present petitioner.
Yes, ma'am.
What is your since when you are continuing?
Since last 2020, ma'am. After the removal of the ex-president, ex-principal, ma'am, that principal in charge against whom the such type of allegation was come. Then after I was continuing, I am continuing, ma'am. I am the Devendra Kumar Tripathi, ma'am. I am the petitioner in WA number 1, 886. Yes, appellant. I am the appellant. Yeah, I am the appellant.
Yes, master.
Lord, here writ appeal is pending. Stay is also pending. But Supreme Court had occasion to have a look at this kind of a case, my lord. In 1995, supplementary 4 SCC 465. 1995, supplementary 4 SCC, page 465. Justice Venkatachalya sitting with Justice Jeevan Reddy. And my lord, may I slowly, it's just a 2-page judgment. And may I slowly place it. May I read? Before the High Court, appellants urged that before any contempt proceedings could be initiated, it was necessary and appropriate for the division bench to examine the prayer for stay, or else the appeal itself might become infructuous. This did not commend itself to the High Court, which sought to proceed with the contempt first. We are afraid the course adopted by the High Court does not commend itself as proper. If without consideration the prayer of stay, disobedience of the single judge order was insisted upon, at the pain of committal of contempt, the appellants may find, as has now happened, the very purpose of the appeal and the prayer of the inculatory stay infructuous. It is true that a mere filing of an appeal and an application for stay do not by themselves absolve the appellants from obeying the order under appeal, and that any compliance with the learned single judge order would be subject to final result of the appeal. But then the changes brought about in the interregnum disobedience of the order under appeal may themselves be a cause to source of prejudice. Wherever, this is what they say, wherever the order whose disobedience is complained of is appealed against and stay of its operation is pending before the court, it will be appropriate to take up for consideration the prayer for stay either earlier and at least simultaneously with the complaint for contempt. To keep the prayer for stay and stand by to insist upon the proceedings upon the complaint for contempt might be in any conceivable case, as here, cause serious prejudice. So what they are saying is that the contempt can be heard along with the writ of appeal and the stay act.
By the principal of the, and the ADM is the petition number 2, my lord.
Has he filed any wakalatama
Yes, my lord, wakalatama is there, my lord.
of the
ADM has filed in her own capacity.
No, as the president of the governing body.
Is the president, the ADM is officiating as the.
But that is not the description, the appeal.
What?
Appellant number 2, you read.
Yes, appellant number 2 is the.
You read.
Yes, my lord.
In what capacity you have arraigned?
My lord. Additional district magistrate, Devgarh, I have mentioned it.
In the capacity of additional district magistrate, she joined with you.
Yes, not my lord, as the president.
What is the description?
My lord. I'm sorry, my lord. That has by mistake later.
I'm surprised.
It appears, the case was to be listed today. But somehow it was not in the list. And when it was mentioned, it appears, my lord, that is why it was taken up at 2 p.m. That is what he writes in this application. And then the ADM Devgad, who is the principal of the managing committee, he requested that the matter may be taken up for on some other day because she is the nodal officer for the general elections. That is what it appears.
We are, we'll see later. Some information is required. But we are not satisfied with your conduct. The present inter-court appeal has been filed. Put into challenge. Please take your seat.
Lordship, please.
Put into challenge an order dated 31/2024, passed in WPC number 25677 of 2020. The matter was not listed today. And in view of listed today, so at about 3 p.m., learned counsel for the appellant, Mr. Ashish Kumar Mishra.
Yes, ma'am.
Made an urgent mentioning before this court, submitting that in a contempt proceeding, that is, what is the number?
2590 of 2024.
CONTC 2590 of 2024.
Yes, ma'am.
24. An order has been passed by a learned single judge of this court directing Superintendent of Police Devgad for production of the additional district magistrate. Which place?
Devgad.
Physical production of Devgad for disobedience of this court's order, said order dated so and so. Stop. He informed this court that the said contempt petition was not listed today and subsequently notified to be taken up at 2 p.m. Whereafter the said order has been passed. Stop. A copy of the order is not available. A copy of the order passed by the learned single judge is not available. Stop. It has been brought to the court's notice that the additional district magistrate Devgad has been appointed as nodal officer by the Election Commission in the ongoing nodal ongoing general elections 2024, for which nomination process has begun today. So stop. Next, we shall go into the merits of the appeal later. So stop. Considering the data.
Mr. Parijal, learned Advocate General, has, on our request, Mr. Parijal and Advocate General has appeared and has brought to our notice a Supreme Court's decision in case of Modern Food Industries India Limited versus Sachidanand Das, reported in 1995, Supplementary Volume 4 SCC 465. Full stop. List this matter on 1 week to be taken up at 10:30 a.m. Full stop. In the meanwhile, the proceedings of CONTC number so and so shall remain stayed. Great. Obliged.